All right. Welcome back to what is sure to be an exciting afternoon on day 12 of the Darrell Brooks trial. I I didn't mark the exact time. I think court should be back in about 5 minutes, but considering the meltdown that sent court into an early lunch, it might take longer than the hour that Judge Darrow anticipated. So I have a feeling, as I've said before, as Brooks gets more and more desperate, his behavior gets worse and worse. So I have a feeling that this morning's antics are just a preview of what this afternoon will be. He's going to be even worse behaved. Um, I have a feeling he will be out of the courtroom before the day's over. Um, I'm curious to see if Erica Patterson comes back because Judge Darrow did threaten to end. She said to end the cross examination. Um, it was direct, so I guess she would come back because assuming the state wants to cross examine her, I don't really see the need. If it hasn't closed, Brooks has been doing his level best to kick down the door for the prosecution to bring in his prior bad acts. The fact that he's on the SA registry um, for predation of a minor, I think, is the charge the prosecutor mentioned. Because once again, if he wants to bring up why the kids don't live with her, the prosecution will come back with, "Why don't the kids live with him?" And he really doesn't want that to come in, or at least he shouldn't. Um, there's a reason why his fired lawyers fought to keep that out, and rightly so. Um, but he's really barking up the wrong tree here. It's not gonna help him. It's only hurting him. He's too dumb to see it. Um, he's trying to call into question his own witness's credibility, which admittedly she was a state witness first, but he had the opportunity to impeach her credibility on cross-examination. He's just rehashing what's already been gone through. So there really was no point in him calling her back, at least not from what we've seen so far. Um, getting into whether or not she contacted him is irrelevant. I'm expecting when the inevitable guilty verdicts come in, he will be dragged out of court. He it's not going to be a pretty sight. Um, I mean, I expect When the verdict comes in, even before it's read, they'll have him stand. There will be at least 4 deputies standing behind him, at least 4. And the minute he starts acting up, he's handcuffed. If not, put face down on counsel table and then handcuffed. Morning, Empty Woods. It is still morning here in Utah, even though we're getting to the end of the early lunch break. Um, he's been on form today. If you haven't seen it, he's getting desperate. He is acting up. He's oh, I have a feeling this afternoon is it's going to be a mess. We're not going to get through all of the witnesses. He's number one. He's wasting too much time. Apparently, courtroom audio is on. Um, Hello, Enigma. Welcome back. Static. Um, but yeah, the process. Well, the judge hoped to get through his witnesses today. It's not going to happen. She she wanted to get to the second group of witnesses at 10:30. That's an hour and a half ago now. We're s- we haven't even finished the first group. His meltdowns are taking so much time. And remember, yesterday at the end of the day, when the judge said they're behind schedule, he said, "Well, that has nothing to do with me. It's the prosecution's fault. They expected to go 5 or 7 days, but they're on day 10 or 11. It's all their fault." But he's the one that wasted all the time asking about the plaintiff in his cross examinations, asking dumb questions. He's the one that has had meltdowns that have caused the court to have to be emptied. He's he's caused cumulatively at least 3, if not more, days of delay. But it's the prosecution's fault. You know, they should have expected him to cause these delays. It's their fault for not realizing. Oh yeah, you reminded me. My lunch was all right, but I in the words of Darrell Brooks, I need to state this for the record and for the jury that I have the best dad in the world. He brought me a nice donut, which will be my mid-afternoon snack. Um, I'm looking forward to it. It's to my left and it looks delicious. I have a feeling I'm going to need it this afternoon because I really do expect this to just be a mess. I I don't expect him to spend the full day in the courtroom. Um, I mean, I do appreciate Judge Darrow starting every day as if she has a blank slate. Uh, Her patience meter has been reset. She, but every day that patience meter is smaller and smaller. So she starts off patient, but she shuts him down quicker and quicker. And as you'll recall, before deciding, "No, I'm just going to take an early lunch," she was throwing her out of the courtroom, or throwing him out of the courtroom. I think I heard all right, so the judge might be returning. I think that's the prosecutor's voice. So we should be getting going here momentarily.
12:10. I do have Mr. Brooks in the other courtroom so that I
Hmm,
could make an adequate record
I had a feeling.
without interruption. We are on day 15 of trial,
And
and
he
today
clearly
has
doesn't have
been a
his
rough morning
headphones
to say the
in.
least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses. And I have done my very
Once
best
again, that
to honor
echo
his
is
rights in
from
that
the court
regard.
stream. It's not me.
Part of this morning dealt with his, from my perspective, disagreement with how I yesterday and in the days preceding that set up what I thought was a very reasonable way for witnesses to be called into this courtroom
Since he
on his
refused to call them
behalf.
himself.
Um, Going back to when the state offered to, excuse me, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is
There
my
is.
not only
I
right,
think
but frankly, my
Brooks is
obligation
clearly not
under
muted. So it's an
906.11
echo from the other
to make
courtroom.
sure that there is an effective
Nothing I can do about it.
presentation of evidence,
Yeah, read that Bible.
of
Ignore the judge
and
with your
exercise
nose in the
reasonable
Bible.
control
It's
over
all
the mode and order of
performative.
interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number one, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following: make the interrogation and presentation effective for the ascertainment of truth.
Yep.
Avoid needless consumption of time. Protect witnesses from harassment or undue
That's his
embarrassment.
entire point
The
here.
next
Harassment
section, a witness may be cross-examined
and
on any matter
embarrassment.
relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's
That's the
testimony.
foundational.
Ordinarily, leading questions should be permitted on cross-examination.
Yeah,
And then
Brooks,
the next part talks
who
about civil
did
cases
nothing but lead, even on his
would not be
direct.
applicable in a criminal case. So that is
Uh,
a statute
he
that
keeps
guides
objecting
what I
to the
do, not just in this
prosecution
case,
leading
but in every
on
case
cross.
that comes before me for trial, or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We were at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 90611. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved.
Or diversity jurisdiction.
Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator,
the prosecution has been a masterclass.
I even stated at one point, I think there's a standing objection. I will note that for the record.
But in
Mr.
general,
Brooks continues, in my opinion, to
I
bring
think
this
this is
issue
a pretty straightforward
in
case,
front of the jury,
aside from his behavior.
Distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted.
It's all performative.
I brought him, I should state it this way. He is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being, we all would expect have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law?
Can you provide a written decision?
Once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday.
Which the state properly
from
offered
my
into evidence.
It's he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that
studiously
exchange went
ignoring
on,
her.
it got, from my perspective, he got louder. He got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I
Yep.
called an early lunch.
He was getting close to
Because of
tasing.
all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceeding.
And remember, she has
but I
never
can't
mentioned
make an accurate
contempt.
record.
He has.
Like I
Not
said,
her.
it's challenging. That is why he is in the other courtroom muted, so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question? Basically, is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other acts evidence. The most recent of
He really
which
wants it in
occurred
for some reason.
this morning with Erica Patterson, and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906-16 and 906-08. Those are generally two of the statutes dealing with character evidence. That would be 906-08, 906-16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character.
He does have
a
a
mother, which is
cuff around his
improper.
ankle, a shock
The
cuff.
only character evidence that would remotely be allowed under,
I think so. They'd only use it if he
circumstances would be character
were
for
to
truthfulness,
become
which would not
violent.
even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906-16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on
I
her
mean,
motherhood.
he's
That's my
misbehaving,
perspective.
but
I
he has,
did
like, if
not
he were to
receive
stand
a
up and
answer
move
to the
from the
repeated
table,
questions I
I'm
asked
sure he
regarding
would
the
be
offer of
shocked.
proof and this letter that he claims was sent by Erica Patterson,
But
and then the photos.
for yelling
The
and
issue,
screaming,
as
I
it relates
think
to this witness,
gagging or
is
removing
a
him is
single
the
charge
better
in the
choice.
case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time
True.
is not relevant. He has not given me any reason as to why it's relevant. The state also,
It's
I
relevant
think,
because he
rightly
says
points
it's
out
relevant.
that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were objected to by the state and that I
It would
sustained,
almost be like he put an axe through
Mr.
the
Brooks
door
would open the
with
door
that question.
to what only could be described as very damaging evidence against him related to the other acts evidence, related to whether he has a relationship with the children or not. And frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not relevant. It is not probative.
It's not even impeaching anything. It's just designed to harass and embarrass.
But certainly one could argue, based upon the questions, topics that the door could be opened to. It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met,
It's all
the nature of
irrelevant.
their relationship now, whether there's been any contact between them since he was arrested and going forward.
None of that has
Because nothing
anything to
that I've been
do
presented with would
with
suggest
November
it relates
21st.
not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong.
It's wrong because he says it
needs
is.
to include an offer of proof as to why he believes this letter is from Erica Patterson and why it's relevant to the issues
I
in
couldn't
this
help
case.
myself. If I could have worked substain into it, I would have.
Because he came in to the courtroom this afternoon and is not in here, but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges
What are the
confronted
bets?
with
He says,
disruptive,
Illinois versus Allen only
contemptuous,
had 3
stubbornly defiant
options.
defendants
You created a
must be given
4th, so you're
sufficient
violating
discretion
my
to meet the
rights.
circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior
And remember,
today alone
Illinois versus Allen says he could just be
was
removed
disruptive.
from the
I
courtroom.
would
This
absolutely
is less
characterize it as
restrictive.
stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it. I would remind him once again of SCR chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin.
You'd have to define courtesy and decorum.
I'd remind him of the golden rule.
Ooh.
Do unto others as you would have them do unto you. Be respectful.
He thinks it's do unto others before they do unto you.
The due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the record for that momentarily. An offer of proof if he wishes to do that related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day.
There's been very little new.
I'd have to look at my notes for the date.
Which means
October what?
she's basically
October 7th,
testified for the prosecution a
witness.
second time.
We did not glean anything new, probative, or relevant
or
in the
contradictory
course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
Now remember, it's the youngest prosecutor who is doing, well, if there's a cross, it'll be the young man doing it. You can tell because he's the one that was objecting. And Brooks is intimidated by him because he's a standard abusing coward that, tries his best to abuse women, but is scared of men. And even though this prosecutor is the youngest, I think he's been amazing. He is so good. And if he bothers with a cross-examination, because I don't know that there's a reason at this point to cross-examine Erica Patterson because, like the judge said, this has just been a rehashing. Um, so he was out of the courtroom. The judge just made a full record of what happened this morning, his misbehavior, why he's wrong, what the rules say. Um, and she's bringing him back in the courtroom to make an offer of proof about the photos and whether or not he can even continue crossing her. So he was muted so that there's no fireworks. He was just performatively reading the Bible. So fast forwarding wouldn't be a bad thing necessarily. Um, but oh, I have a feeling though he's on his way back into the courtroom. I don't think he stays there too long. I'm guessing he's removed at least one more time this afternoon. He he's pathologically incapable of behaving. And I I just I don't understand. He has 76 charges. How many of those are related to Erica Patterson? One, maybe two? And yeah, it's a felony. You know, he's facing prison time for it. And I'm going to sneeze, but I mute and the sneeze hides from me. Um, I just I don't understand why his primary focus isn't the 74 or 75 other charges. I'd be, my primary focus would be on the deaths. I'd be trying to prove there's no intent there, that there's something mitigating in some way, but
Right, so we are
he's focused on
back
this
on
one
the
event
record.
because
I've been advised
that's
that
where he
Mr.
lost
Brooks
his
does not
power.
want to come over to the main courtroom. Mr. Brooks, I'm advising you, you are invited back to this courtroom.
Of course, he doesn't want to
It's my
return.
sincere hope that you want to come back here. I see you're reading something.
They don't like child
it's-
murderers either.
We are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay in that courtroom.
Remember, we have to remember this is hard on him. He's the real victim here.
I've been advised he can hear and see.
That's why he's performatively reading the Bible instead
Brooks,
of answering the judge's question.
I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back
Remember,
here?
by his
Yes or no?
rules, failure to respond is a tacit agreement.
The audio is on. Would you like to come back to this courtroom, sir?
You're unmuted. So I'm finally unmuted.
You've been unmuted for a while since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
Oh, here come the headphones. Because remember, he's hard of hearing when he wants to be. His shoulder hurts when he wants
Mark
it
to
to
reflect with
hurt.
putting on the headphones.
What's going on?
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't say nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
You haven't been held in contempt.
Then why am I even over here?
So that I could make a ruling and make a record without an interruption pursuant to my authority in Illinois versus Allen.
That's it. It's all
So did you make your
to stall
did you make your record?
and
I
to
did.
Am I ever
exert
gonna get a chance to
control.
make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
She hasn't held you in contempt.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if
keep
you
being
don't
held in
answer yes
contempt.
or no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
And it'll be real
What
hard
conduct? I didn't
questioning
consent to
By
being
witnesses
held
from
failing
there.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
Your
So twice now
behavior
I've asked him, he has not
forfeited
answered
your
a yes or
right.
no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Hold.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
He's such a child. What are the bets that when the camera comes back on, he's still in the other courtroom?
I think I can hear everything she's saying perfectly clear without the headphones.
Well, then you should have put the headphones on. It's your fault. Uh-oh, she abandoned ship. Judge abandoned ship, but you know what that means. It means the sovereign citizen's in control now. Because this is maritime admiralty law, even though that makes absolutely no sense, but I still think he's not going to be in the courtroom when the camera comes back on. He's just doing this to delay and exert control, and he's going to find that he doesn't have the opportunity to question witnesses. So, I mean, it is more entertaining for us when he is in there. To be fair, he he's and that's it. You know, that one exhibit at the beginning of the trial, the dash camera when the officer responded to Erica Patterson and Nick and Corey, the microphone picked up mention to him beating her up the day before or something. No one heard that. Yeah, hard of hearing, Mr. Brooks says, "It's clear as day it's in there." He's the only one that heard it. The judge finally did when she was specifically listening for it with headphones away from, in her chambers. But if the judge is talking to him, I can't hear anything, Your Honor. I'm so hard of hearing. It's the standard sovereign citizen. If it will give him an advantage, he has a problem. It's, oh, my shoulder. You need to take me to the hospital. They slammed me to the ground and then handcuffed me. Oh, every sovereign citizen has an injured shoulder somehow. So it's way over an hour. I mean, court started 4 hours and 15 minutes ago. Take away an hour for lunch. So, of 3 hours and 15 minutes, I think he's wasted 2 hours of that or close to it. So, once again, when he said yesterday, it's the prosecution's fault we're behind, not mine. That's standard abuser behavior. Well, I mean, the judge assumed 35 minutes each based on how long they took yesterday. And of course, he's like, "Oh, well, at least one of those is going to be a lot longer than 35 minutes tomorrow." Which one? I don't have to tell you. Except everyone knew it was Erica Patterson. So he thinks he's the only genius in the room. He thinks everyone is playing to his rules. They're not. He's the moron. He's the one that's going to go to prison. He's the one angering the jury. He's the one angering the witnesses. I mean, yesterday we saw the barely concealed rage from Nick Kirby. I mean, if we saw it, the jury saw it. The jury saw how much he hates Darrell Brooks. They heard the venom in his voice. They heard that Nick Kirby dropped his coat, getting ready to knock Darrell Brooks out. And yet, Darrell Brooks thinks he's in control. Everyone's there for his amusement.
Record, it's 12:48. All right, let's take up the issue of the letter and the photographs and your offer of proof, sir, if you have one.
Okay, I don't need no offer of proof.
Then it's
I'll
not
ask you
coming
a second
in.
time. Do you have an offer
We
of proof
can
to
go
provide,
past all
sir?
that. We can go past all that. I don't need to ask them questions.
Yeah, keep
Too much of
keep
an
looking
issue,
at
too
the
much of a
ceiling.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the
I just said no. I just said that.
All right, thank you.
You
based upon
said
there
I
being no
don't
offer of
need
proof, then,
to give you an offer of
my
proof.
decision stands.
That means his
As to the
direct
continuation of the
examination is over.
examination of
Well, Unless that's
Ms.
just
Patterson, I would like an offer
related
of
to the
proof
offer
as
of
to
proof
what you
to the
believe
letter.
her probative and relevant testimony will be from this point forward.
I mean,
That's
I
true.
don't know how she's gonna answer the rest of the questions. There's not that many questions left. I was almost done.
Sure you were.
What topics generally were you going to question her about?
He's so mad. You can
I
tell
guess I'll have to look in
when
here
he
because so much been
studiously
happening
avoids
since
looking at the judge,
over the
looking at
past
the
hour and a
ceiling,
half or so.
looking at the wall. He's so mad.
I can tell you one thing. I don't intend to. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination,
I
or
don't-
already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well,
Well,
Mr. Brooks, this is your opportunity to prevent relevant and probative evidence. But
Not
under
repetitive
90611, she's already been
evidence.
questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that haven't been
Topics that you
covered.
haven't already covered.
What, to pursuant to the police report or something? Is that what you're asking? I don't
I'm
understand.
asking you. I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you said related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions.
No,
That's
they
why I'm
weren't.
saying it was only.
Is it a statement that she wrote?
No.
I don't know if it's a statement that she wrote in here.
Do
Possibly is.
you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson?
No.
It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about so I know with specificity?
Oh, I'm looking at it now.
I have questions about my car warranty. Can you help me with that, Scamorama?
How many officers did reports? Because it seemed like it's more than just two. At
That's
least from this paperwork.
for you
more
to
than
know.
two.
It's not their job to fill you in. You have the discovery.
Show me what Mr. Brooks is referring to. I can maybe help and try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. I have to snatch it.
So I've got pages 2 and 3 out of 6 from Detective Barrett's report under Waukesha Police Department incident number 21-047533. This is one of the two reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st.
And once again,
and then on November 22nd.
They-
This is the first statement.
she did not make these reports.
Is that the officer you just said?
Yes.
So it would generally be
What about
inappropriate
that report
to
you want to
ask
question this
her
witness about?
about the contents of the
The
report.
report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson on?
Your Honor, I just
He's
stated
so
3
mad.
times, I would have to read a little bit of this to form the questions.
Under my authority, under 90611, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand
And meltdown
and then we'll bring the jury
coming.
out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand what you mean by closed.
It means
I'm
you
not
can't
allowing
ask
to
more
ask her Any
questions.
additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
How do I, first of all, the report isn't even in order. So I would have to essentially.
That's
read
your fault for
at
not
least
being
some of it,
organized.
even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness
If
out.
you're unprepared,
will come
that's
out,
on you.
And you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I have to
I
do that
mean-
in front of the jury.
Man,
She's
I object
trying
to that
so
ruling, too.
hard.
Can you
A
give me
little
a
time
lawful
here
law why?
The
saves
objection is
time
noted for the record. If
from
you
a
start
second
interrupting me when
trial.
the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being
Do
held
you
in
take
contempt again?
Luna?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your
So
right
I might
to
as
be
well
present.
have just
No
stayed
such
over there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
gonna get held in
Brooks,
contempt.
that decision.
She has
is
not
for
held you in
and alone
contempt.
to make,
She has
and it is
not
based on your
threatened to
conduct.
hold you in
gonna
contempt.
Just take me over
continue?
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're
omitting-
attempting
She
to
has
hold me in
not.
contempt. That's what that is.
No,
No,
that's not contempt.
it
So
is
is it
not.
civil or criminal?
It's not contempt.
Why am I being
Mr.
held in
Brooks?
contempt?
He's
That's
ridiculous.
You
the
in
whole-
here because
That's
He
the whole
is-
you're
reason
gonna
I
need
didn't
to
want
call
to
the
come.
next
Stupid.
witness, and I'm gonna need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
No,
Well, I'm finding.
you
a
were
reason,
finding a
sometimes I
reason
find a
to be
remove
held
you
in
based upon
contempt.
Your disruptive
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I want
Obviously
you
you
in this
do.
courtroom.
Obviously you do. You brought it up before we can even get to.
All right, Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though
did
it will be
I
short,
actually forfeit that right?
you have
Yes,
forfeited your right to be present. That
And
is
how
the-
did I
the
forfeit that right?
judge
Your
did not take
Um,
the right.
We're
You
going off the record so
forfeited
that he
it.
can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by
The judge should have
rules
asked.
of decorum
You
and
intend
civility,
to cross
and
her
if you're willing to conduct
first,
yourself
because otherwise it
consistently
might just
within
be
that, then I
back
will
and
allow you
forth.
to come back over.
So why am I being held in contempt now?
I'm not holding you in contempt.
exactly.
And what did I do?
All right, I'm gonna
He
step off.
said
You
you may as
interrupted
well
repeatedly.
remove me.
I'm gonna step off.
she didn't do it. He did it. He's like I said, I didn't expect him to stay in the courtroom very long. I mean, I half expected when they came back that he would still be in the other courtroom anyway. Um, he he's just getting more and more desperate, I think. He sees the writing on the wall, and as it gets closer and closer, in, as he puts it, their rush to judgment, his new word of the day, he's trying to delay that. And so the closer they get, the worse he acts. Exactly. Well, 50 minutes because they came back at 11:10 my time, 12:10 their time. So it's been 50 minutes. And at some point, he not only does he forfeit the right to be in the courtroom for the cross examination, at some point he's just going to forfeit his right to question witnesses, to call witnesses. Good point. So it will take us into about an hour. And especially if, as soon as they come back, the state says, no questions. And then they have to drag him back and then argue with him about, oh, well, I don't want to call the next witness because the state didn't get the right witnesses here at the right time, even though I wouldn't tell them who I wanted at this time. And he's going to find something to complain about because everything's a conspiracy against him. Nothing is his fault. Uh, I mean, why did you bring me back into the courtroom when you were just going to find a reason to hold me in contempt? She has never held him in contempt. She has never threatened him with contempt. He is the only one who has brought up contempt. She has tried multiple times this afternoon to keep him in the courtroom. It's his behavior. He practically begs her to throw him out, and then when she obliges, he throws a fit. How dare you throw me out? It it's just more evidence of his abusive tactics. And the thing is, outside of the judicial system, it's always worked for him to an extent. And he has a very long criminal history. I don't know how long he's been a sovereign citizen, uh, if he's represented himself before. I don't know his prior in court behavior, but this is ridiculous. This in the morning stream, the Michael Wayne Parsons was brought up. We don't have video of that, but I think even he was more agreeable than Darrell Brooks. Um, the what Anthony Troy Williams, the private attorney general, his trial last year was a breeze compared to this. And he's one of the more obnoxious sovereign citizens. Of course, he was never in the courtroom. It was all by video from a holding cell, and he was muted a lot of the time. But I mean, there's only so much the judge can do to ensure a fair trial if the defendant does everything in his power to disrupt it. I mean, like, if they were to hold him in criminal contempt, uh, it's just I think the reason she hasn't is because what's the point? She knows he's in jail for life at this point. So, I what's she going to do? Order him to be held in solitary confinement for 30 days? Send him to the hole? I don't think she can actually do that because that's jail administration or looking forward, prison administration. Um, she can't fine him. He has no money. And if he did have any money, it's all going to the victims at some point. So I think that did help. I just I've seen misbehavior even with attorney. You know, uh, People with attorneys misbehave, but he- I really think they need to move the shock cuff up 2.5 feet roughly, and maybe then the threat of a zap to the nuts keeps him in line. And that's it. You add another hearing, it just adds more delay. It gets him more time in court to pontificate and cause trouble.
Make sure all the monitors are on.
So it's just
You are
easier
unmuted,
to
sir.
do this
The jury is
under
on its way
Illinois
in.
versus
Well, will be
Allen,
shortly.
remove him from the courtroom, and
I'm going to mute you if you do that, sir.
I'm not gonna do it with the jury. That's why I asked now before.
you always wait
I
until
addressed
she
that in my
says
opening,
send in the
Like
jury.
remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record?
She's already addressed it.
Will I at least be told why I'm held in contempt?
She
when I didn't
hasn't
do that?
held you in
Civil or
contempt.
criminal?
That's a misstatement of what I did, sir.
So why am I
I
over
will
here?
advise when the jury's coming
It's
in, and if you
his
can't be quiet,
game.
you're going to be muted, sir.
You gonna mute me anyway?
He thinks he's playing
Not
his
if you're quiet.
game. He
So I
sets
gotta
the
be quiet
rules.
like a little kid?
It's not what I said, sir. You have to be
That's what
respectful.
you said.
You have to be respectful of the proceedings.
But nobody has to be respectful to me though.
That's a mischaracterization as well.
They
So
have
can I say
gone
for the record that
over and
two of your
above.
bailiffs was just making gestures behind my head, and I seen them through the TV screen and made me feel uncomfortable?
Seriously?
Jury's coming in. Please rise for the jury.
So that's not gonna be addressed.
Mr.
Okay?
Brooks, I'm muting you. Oh, okay.
That's the federal district. That was appeal.
Case law from the Middle District of Pennsylvania. Don't know what that's involving, but new case law for something.
Can I have the preliminary instructions for a second? Oh, sure. You should just keep them. They're nearby. Thank you, everyone. Please be seated.
But how is he going to play the victim if he grows a spine, gets thicker skin? It's all
For
about
the
playing the
record, Mr.
victim.
Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness?
I knew it.
Right.
I
Thank
knew
you,
it.
ma'am. You may step down. Thank you for being here.
I knew it. And now they have to go through the whole circus again.
All right, the defense may call its next witness, please.
He's going to sit there and sulk, though.
Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
So how long am I supposed to stay here now?
You're supposed to call your next
I'm going to
witness.
excuse the jury. We'll hopefully have you back shortly. All rise for the jury, please.
Now he's going to come back to the courtroom, cause a scene, get removed. And if he does, under 906.11, she can say, you know what? You're not participating in good faith. You're not calling any more witnesses. You're just trying to obstruct and delay and inconvenience the witnesses at this point. They're released. Done.
All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave.
I
the
think they've
courtroom
made up
because
their
it appeared to
mind.
me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness?
What's the point? You're just going to kick me out again.
You're not muted. You're unmuted.
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois
I
versus
expect
Allen, Mr. Brooks
deliberation
was
to
not
last at
held
least a
in
day,
contempt,
but most of it
although
is
that is one of
filling
the
out
possible
paperwork.
ways for a trial judge to handle a
And it's going to
defendant
take
who is stubbornly defiant,
at least
disruptive, and
a full
contemptuous.
morning
That is not the
to
only way
read
in
the
which
jury
a judge
instructions out
can
loud in court.
address a defendant that is being
And he'll
discourteous,
misbehave through it, so
disrespectful,
it
and
could take all
disruptive.
day.
So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state
They
of
have
Washington,
to agree on each
from
element
their
of
Supreme
each
Court,
crime.
State versus Davis, 461.
So that'll take
P.
a
3rd,
while.
1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are
That's
welcome
why
to
you're
come
in
back
there.
into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last
They better
time.
get good
Would
meals.
you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more.
She hasn't held you in
Mr. Brooks
contempt.
is not answering my question directly. So based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that
You can't-
courtroom.
You can't answer
Mr.
for
Brooks?
me. You can't do that. You can't do that.
But
Mr. Brooks, I'm
failure to
advising you that I
answer
will-
is a tacit
He's interrupting me
agreement by
once
your
again.
rules.
From
Okay,
the
you
other
talking.
courtroom.
You the one talking right now, so don't do that.
I'm going to
No.
mute him because he's not being respectful and he's just spouting off. So he did not answer my question directly. He has not
Exactly.
reclaimed his right to come back into the
Exactly.
courtroom because number one, he has not requested it. Number
And
two,
he's
he hasn't
desperate.
answered my question about whether he wants to come back in. And number
He's
three,
mad.
he
He's
hasn't
desperate. He
stated or
sees the writing on
demonstrated
the
a
wall.
willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I'll give him
It's
one
going to
more
be
opportunity.
difficult to
So that
question
it's abundantly
witnesses
clear
when
on this
muted
record that I
in the other
am honoring his
courtroom.
right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your
No.
next witness?
Don't try to seem like you're trying to honor my rights now because you haven't been
Okay,
doing
he
it before.
is, again, not
Don't-
answering the
don't-
question
don't try to
directly.
put on, no, don't,
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on. And I
So,
confirmed that he
Are
can
there
see
going to
and
be any
hear
more
as
witnesses at this
well,
point, do you
based
think?
upon the court personnel that are.
I have
in
a
the
feeling
other
this is
courtroom.
it.
So I'll make another finding that his
I have a
appearance
feeling
from the other courtroom is the functional equivalent of him being present in this courtroom.
I have a feeling
Mr.
that
Brooks,
she
before I unmute
calls
you,
it
I am
closed
going to
and
advise you, I will ask
they do
you
closings on
um,
Monday.
to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses.
I think we're
So I'm
done.
going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I gotta be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made a
gotta
record
answer
of that,
everything.
sir.
I have to answer everything.
You
though.
were
Everything you ask me,
misbehaving.
you expect me to answer, but then when I ask you questions, you never have to answer
The
anything.
court does not have to
I just
answer
put on
your
the record
questions.
that
She
two of
put
your
it
bailiffs just
fully
made
on the record.
gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
But it's all a
Mr. Brooks,
conspiracy
I didn't
against
address
him.
it because frankly, you keep
His
interrupting
failure
me,
to
and then I
prepare
have to deal
is a
with the interruptions and make
conspiracy
a record
by
regarding that.
everyone
So
else.
I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that. And if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't
But
answered
your
my
question isn't his
The court's not
game.
going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
Exactly.
They're
Mr.
not
Brooks.
a delay and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination.
So
It is on
my
the record.
nephew
If there is a
turned
conviction, you
four
can raise whatever issues you
10
want
days ago.
on appeal if you are convicted. But
He's
you don't
better
need to have this
behaved
back
than
and forth
Brooks.
every time to further make the record when the record speaks
I mean,
for
he
itself.
causes mischief.
You were given
but, like,
plenty of opportunities
when
throughout this
he
trial to make offers of
Opened
proof,
his presence
to
at his
state your
party.
legal
He
reasoning
gets
for either an
he'd
objection
get excited. I'd say,
or for a question
say
that's
thank
being
you
asked,
to
or
cousin
for a
so and
whole
so.
host of other things.
And he'd shout,
But
"Thank
right
you,
now,
cousin
you're
so
not
and so."
doing anything legally relevant.
A
You're
child
being
can learn.
disruptive.
Brooks can't.
I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout
That's it.
this case.
She
I will
enforces the
advise
rules.
you
He doesn't make the
that
rules.
if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off.
Of
so
course
I
he
would-
did.
Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
She trying to say something to me? Yeah.
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones. You
Yeah,
choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that
They
I
don't
don't
help
have to
you
hear the
speak.
disruptions.
They're so you
Okay,
can
well,
hear.
then why should I need to hear what
So
you
let
saying?
me be clear, sir. And you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
It's done.
I will ask you
It's
one
done.
last time, sir. Who is your next witness?
It's done.
First of all, is she talking to me again?
Yes, she is talking
This-
to you.
We gotta keep doing this little childish stuff.
You're the child.
I gotta sit up here and I'm supposed to abide by every single rule.
Yes.
But no, nobody else gotta do that.
They do. They would
The
be
record
locked
should
up if they
reflect
did a
that Mr.
tenth of
Brooks
what
is
you're
spouting
doing.
off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these
I mean,
proceedings.
if the prosecutors
Well,
did
yes,
this,
refusing
they would be
to
locked up for
answer
93 days
no
already.
questions. Mr. Brooks, you
But it's
That's
a
not my
are,
name.
conspiracy
I
against
told you I
him.
don't
It's
consent to
unfair
being
towards
called that
him.
name.
sir, you are hereby advised, this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to
You
present
can't do that.
any
Show me what-
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this
Exactly.
process.
Show me that it's
It-
law.
it-
That's
it
all
would
I'm
be
asking.
over.
Show me that it's law
The
for what?
prosecutors
Mr. Brooks.
would
How
be
can
fired.
I forfeit not being able to have a defense? Are you kidding me?
You are being given
I'm
every
asking is that you
opportunity
conduct
to put on your
yourself
defense.
With dignity, with decorum, and with respect. I will
Okay.
gladly bring you back into this courtroom so you can present your additional witnesses.
Your
But you
Honor,
need to ask me to come back into this courtroom.
with all due respect,
You've shown none.
I'm tired of having this back and forth with you every day. It's not my intention
Then
to come in here
stop.
and have this.
You
interactions with
are
you
the
every day.
clown.
It's not. Regardless to what
You
may
bring
think,
the circus.
regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding.
Well, that's
So if
your
I don't
fault.
understand something, I'm
Hire
going
a
to ask
lawyer.
question. I apologize if it makes you feel that I'm intentionally trying to delay the
You
proceeding.
are.
If I'm intentionally trying to be disruptive, because that's not the
She-
case.
She doesn't need
And
the
it- and I
gavel. She
feel
needs
very,
blue bacon's
very,
big
very,
bopper.
disrespected every time the record is made, making it seem like that's what I'm attempting to do.
That is what you're doing.
So of course it's gonna frustrate. Of course it's gonna make me a little bit upset.
I hate this echo. I
And I
only
just
want to
want you
hear
to
him
understand
once.
that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom.
It is.
It's not a dispute. It's not up for
Then
debate.
why do you try to set the
You
terms?
control what's going on in there. It's not a dispute.
You're trying to control it.
But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm
She
interpreting.
has not told you you're in
Because one of the
contempt.
three
You
things
keep saying
that's
you're in
cited
contempt. She has not held
in
you in
Illinois
contempt.
versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt. If
What's
I'm-
the
if
third,
I'm not
Mr.
under-
Brooks?
The third
the
is
third?
removal.
The third is Removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay.
Adding
So
video
now-
is less
now, where does it say after
restrictive.
that
This is
having me
less
on,
restrictive.
a headset or being able to see and hear and all this and this, how is that not
Besides which,
prejudicing my defense?
Illinois
Sir, you
versus
can raise
Allen
that issue on
provided
appeal.
free options.
You
It
can
This is
raise
why I
that
say
issue
that.
on
limit.
appeal if you are
This is why I say
convicted.
that.
Limit
This is why I
those
say
free
that, though,
options.
because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I understand that, sir.
Then
fully aware of
behave
that.
and return to the
So I'm not
courtroom.
fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
Behave and you
If
will.
you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes.
what
So
did I do
I'm
when
not
I
going to
said
have a
tonight?
debate with you about the law. I will ask
mean,
you again.
cranial shock
Would you
is, I
like to
think,
come
the
back
only
into this
option here.
courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you going to kick me out?
That's
Sir,
a no.
it's a yes or no question. Would you like to come
Well,
back
my
into
answer,
this?
my answer was based on the reason why I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth.
Then
and back and
behave
forth.
and you won't.
It makes essentially it wastes time, really.
I'm well
You
aware of that,
are
sir.
wasting the
That it
time.
delays the
Yeah,
proceedings.
But
You
then it's laid
waste
at my feet
time.
as if that's my attempt. You think I want to be over here?
Yes.
Sir, I don't know what you
Yes.
want or don't want at this time. I know that we need to
We
complete this
fully
trial
believe
and
that
that you
it's
have
your
frustrated
intent to
today
frustrate the process.
more than ever before the ability of this court to do that.
Well, I apologize for you feeling
Oh,
that way.
yeah, right. You apologize.
Nobody seems to
I
take that.
apologize
I'm just as frustrated
that
as
you
everybody.
feel
Probably
I'm
more.
misbehaving.
Then I suggest that you conform your conduct to the requirements
There
of
is no
courtesy and
conduct,
decorum
Your
so
Honor.
that you don't run the risk of forfeiting your right to be present. But
But there
that
is
falls
no-
on you and you
Yes,
alone, sir.
this is
There is no
poor
conduct.
conduct.
I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't
She
think that's
can't
accurate.
make it
I think you know
any
exactly what you're
clearer.
doing.
If that's what you think, that's fine. I can't
And
argue with
you have
about your
demonstrated
opinion.
throughout this case that you pay attention to
He's
witnesses'
demonstrated
testimony,
he's
that you make
capable
cogent
of
and
behaving
coherent
when he
objections.
wants to.
At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an
It's
issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel.
She held
And you did so
two
knowingly,
long
freely,
hearings about that.
voluntarily, and with a full understanding of the disadvantages and advantages of doing so.
He's so
Meaning
mad.
advantages of having an attorney.
I mean,
the
look at his
disadvantages of
disrespectful body
doing it
language
on your
here.
own, and you made a
That
deliberate
could get an
decision
attorney held in contempt.
to
Your Honor, that's
represent
not fair.
yourself,
Your Honor,
and
that's
that
not fair.
comes at a risk to you of yes,
Exactly.
at
It's a
times
trial,
not fully
not a
understanding
debate.
the law, the rules of evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because.
So I'm going to do the
paperwork changed.
following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like
They
him
do.
to be brought
They do.
over. And he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer. And after the 3rd time, I will make the appropriate
and let
finding,
the jury
but I
see
will
it.
do that outside the presence of the jury. But we are going to continue. So we'll go off the record.
The
and he will go back
jury
over here.
is so
Thank you. We are
furious
in
by
recess until
now
that happens.
because they know that this is all wasting their time. They're fully aware. They're not at work today. They're not at home today. They're not with their kids today. They're dealing with a jackass clown. And nobody likes that. I mean, maybe Brooks thinks this is endearing. No one else does. And I mean, he still thinks this is the judge being unfair to him. He doesn't understand. It's entirely due to his behavior. It's not hard to understand. Even a 3-year-old, they might not like getting sent to timeout, but they understand. They're sent to timeout for using their markers on the walls. They're sent to timeout for pulling the dog's tail. They understand they can avoid timeout by not doing it again. Brooks is incapable of any of that analysis. I mean, the judge put it on the record in the second day of the Ferretta hearing. The hearings to determine if he was competent to represent himself. She didn't specify which one. We don't have his medical records. She specified, though, he is diagnosed with a personality disorder. He has displayed that again and again and again. But that doesn't impact his competency to represent himself. And that's it. I can't comment on his mom because we haven't seen her. I mean, she clearly has more sense than he does. She wrote a letter to the court begging the court not to let him represent himself. She recognizes that he has issues. My understanding, I haven't seen the letter. My understanding is in the letter begging the judge to keep his attorneys, his mother stated that he is bipolar. So the reality is the waterworks might not actually be performative. That might just be on a low with being bipolar. And then this is his manic stage. Once again, I'm a lawyer, not a psychologist, not a psychiatrist. Um, but he and it's possible. It's possible there was no discipline, but there are people that they're over disciplined, and this is the response. That the parent hovers over them, controlling every decision, and they reach adulthood and they say, "Hey, wow, I'm in control now. I'm going to do whatever the hell I want. No one can control me. And I've never made decisions for myself. Therefore, I'm incapable of it." And that could be it. That because he does think he's being persecuted. He and I mean, is the judge holding him responsible for his actions? Eventually, she's being as patient as she possibly can, but she's doing everything she possibly can to give him a fair trial, but it's all persecution. And it, I mean, based on what we've seen, I wouldn't be surprised. But like I said, it could be the Newton's rules, the equal and opposite reaction. He's controlled throughout childhood by an overbearing parent or parents. I I don't know if his dad was in the picture or not, but sometimes it really is just overly controlled, and so they respond in adulthood by being completely out of control. I really think there are no more witnesses. I mean, and I said that before the judge even suggested that she was going to shut it down. Um, because once again, under 90611, if he refuses to cooperate and call a witness, she can say, "All right, you don't have any more witnesses." Done. I think that's going to happen. It, at this point, I simply can't see anything else. He's got such a full head of steam and has decided that everyone's out to get him. I don't think at this point it would be possible to convince him otherwise. It's I do hope that I think her patience is done. Like I said, I admire that she comes in every day with her patience meter reset, but smaller. And she did. She permitted him to add her to his witness list and to subpoena her. He accepted for value the subpoena form that he was provided in order to subpoena her. Um, I stand by when I said I think that'll be a bad idea because the prosecution's going to come in with the jailhouse phone calls and say, "So, isn't this how your conversation really went?" But, if he calls her, that's his risk. But it's not going to play out anyway because he's not going to call any more witnesses, I don't think. And that's his fault. I mean, I don't know how an appeals court would possibly be able to say he wasn't given due process. He was given every opportunity to present a meaningful defense. But that opportunity isn't endless. At some point, through misbehavior or through cumulative evidence or through abuse, at some point you just forfeit that right. It as the judge has said, you have constitutional rights. Those rights are not unfettered. You have a First Amendment right to freedom of speech. That freedom of speech is drastically curtailed in a courtroom. You have a Second Amendment right to bear arms. You do not have that right at all in a courtroom. You have a Third Amendment right to not be compelled to quarter troops in your home. That probably is unfettered in a courtroom because how are they going to do that? And that's it. Calling his mom is his right. There is a consequence if he calls her, and that consequence is cross examination. It's the fact that prosecution might get really damaging evidence out of her that they didn't even intend to do. The prosecution could have called her. They didn't feel the need. Of course, they weren't planning on questioning about jailhouse phone calls. But if he brings it up, they'll definitely bring all the jailhouse phone calls where he asked her to testify a certain way or to withhold evidence or manufacture evidence or whatever. And i- if mom does it, she could be charged with suborning perjury, or just perjury in general, or that they could add witness tampering charges. I mean, it it's dangerous. Um, okay, jailhouse phone calls are recorded. Period. People are arrested all the time on relatively low level things. They call their friend and they say, "Hey, get rid of the evidence," or "Hey, don't testify.
The record
Hey,
to reflect that
help
Mr.
me."
Brooks is present in the courtroom in person and in custody
Before
wearing
the
a
next
suit,
hearing,
suit tie.
prosecution calls
Actually,
the
his
attorney
suit coat
in
is off,
and the
but
defendant
he's
in, and they
still
play
wearing a
that
mask.
phone call and they say,
And the
"So,
jury will be brought out
are
and
you going to
will be asked to
plead
call your next
to the
witness.
misdemeanor we charge you with? Or are we going to charge you with felony witness tampering?"
We still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
Exactly.
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
You failed to answer her
Make no
questions.
such
Was that a
agreement with you, sir.
tacit agreement?
So that means you can answer a question then.
She does not have
Will we be
to
addressing
answer
subject matter
questions.
jurisdiction
The
on the
jury
record,
is
and
on
will
its
it be
way.
verified and
She
proven?
has already made a full record about the games you play when the jury's on its way. She's sick of it.
A non-responsive answer is a tacit agreement, Your Honor.
No, it's not. How
Jury's
about
coming
all
out.
your non-responsive answers? What are the bets? Is he going to call anyone? The judge has already pointed out she
Thank you,
doesn't know
everyone.
what
Please
a
be
tacit
seated.
agreement is.
The defense may call its next witness.
Who's here?
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
I mean, by his pronunciation, he's a
Go,
sovereign citizen.
Deanna Aldridge.
Deanna Aldridge?
Wow.
All right, very well.
I thought we were done. I'm shocked. I'm shocked. Like I said, he's a sovereign citizen. How angrily is he going to question this witness? That's it. He's been performative this whole time. He's trying to exert control. And that's it. The judge said personality disorder. She didn't specify. So sociopathy is a personality disorder. So is this going to be, was I honking my horn? Did I have window tints? Or do you think this will be a witness that actually helps him? Because once again, sometimes it's best for the defense not to call any witnesses of their own, just to do a vigorous cross-examination to discredit the prosecution's witnesses.
I'm sorry, Your Honor. I think she was in the other building. So.
And it's
That's all right.
possible
Thank you for letting us know.
that that's the case here. And that's it. For every witness he's able to call that says, well, I didn't clearly see who was driving the SUV. There are others that say, yes, I saw the driver. It was you. And the better tactic is to impeach the credibility of the people who can identify him than the people that say, I couldn't see you because I was running away. Because they're still bringing in more information that, yeah, I was there. I'm an indirect victim. It's I mean, I don't know for sure why he's in a protective unit. Like, it could be due to the nature of his crimes. It could be his 15-year-old criminal history. It could be
Good afternoon, Miss Aldrich. If you would please make
the
your way to
infamy
witness
of
stand.
the
It is
parade.
up by me.
It could be he's just pissed off so many fellow inmates that
Standing, raise your
he
right
needs
hand, and
protection.
my clerk Teresa, who's on my left and will be across from you, will swear you in. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth?
It also could be that.
So help you God? Yes. Thank you. Come up and have a seat.
But he is going to have a
First
bad
thing I will
time.
ask you to do is to
in
state
prison.
your first and last names for the record, and then spell each.
Okay. Deanna Aldrich, Deanna. Last name is Aldrich.
Thank you. Go ahead, sir. Your witness.
Good afternoon, Miss Aldrich.
It's Deanna Aldrich. No idea why she's there.
Direct your attention. Well, first of all, let me back up a little bit. What do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
Yes.
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Yep.
Back up a little bit to the thumping noise.
So I think he's trying to get
Can you
at.
describe
Did you
that
see
thumping noise?
me
Would it
run
just
from
be
the SUV?
a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV.
I
I
gave
did.
Do you recall how that SUV looked at that time?
when my sister-in-law was
smashed to
pregnant with my
smithereens.
niece, the oldest. I gave everyone children's books for Christmas that
Do
year
you recall if the
to
red
read to
SUV
her
was still running at the time that you observed it?
Yes.
because I
And at
found
some
it
point,
just
did
that
it
important
cut off?
to read
Yes.
to the kids.
And what did you see from that point?
Before I seen it shut
Close
off,
eye,
I seen
you've
it go
missed
forward in the
quite a
driveway
show.
and then back up like 3 feet, and then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
Like I said,
Uh,
I think it's all
what do you recall?
so you didn't see who ran from the
As far as
SUV,
Description wise.
even though there
Dark
are
hair,
eyewitnesses who did.
possibly white or purple or whatever color shirt and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So
He falls in that range.
I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down.
That's
yes.
quite a leading.
And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around. To
That's
front
the
of my
only
building.
Tolkien book I finished.
Did you see where the individual went from
I
that
couldn't
point,
get
or
past
could you not see
Bilbo's
because of
party
the
in Lord of
position
the
the building?
Rings.
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street though. He
Okay.
was in the front yard on the grass.
Did you at any time observe this individual jump over the hood
That's why
I was
I didn't
running
make
in
it
and out
past
of my
Bilbo's
house,
party.
so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you was trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
Seriously.
I do not recall.
Seriously.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
I mean, there's a reason why the state didn't call her.
Before that evening,
He shouldn't have either.
had you ever noticed that SUV before that evening?
No.
No, there was not a wrecked SUV in her neighbor's
Did you
driveway
speak with any of your
before
neighbors to
that
inquire
evening.
who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were gonna walk up to the vehicle, but they did not.
Flying was
I
the
yelled
better
at them and
option,
said,
but
"Don't touch it."
he
So that kind of would be
today
fair
has
to say
been
that kind of startled them and
mostly
stopped them in their tracks.
meltdown.
Do you recall how many people there were?
Maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
This isn't helping. This isn't contradicting anything. She's just saying, yeah, I didn't really see anything. She's not helping you. You're just wasting time with a witness who didn't see much.
If you recall, did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
There was this alien spaceship crash landing, damaging the vehicle, and then taking off again.
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, which street did you say?
Arlington.
Arlington. I apologize.
That is the general direction he ran. there's a possibility that that could be a good idea, but it's also a possibility they shut him down. I wish I had it open for that rant he had last week.
Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Why would they? She's not a good witness. She didn't see much. And again, the testimony is he ran down Maple in the direction of Dunbar. She said Arlington. They're in the same direction. It's just Dunbar is on the west side of Maple. Arlington is on the east side of Maple. I
Do
mean,
you recall
since
the
he
name of the
can
officer that
argue
interviewed you?
in closing, it could be more fireworks than waterworks. Exactly. You didn't see any on your flight today, did you, Si? Well, it was the black hole from his density that drew them to Earth in the first place.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor. Thank you.
Thank you, ma'am.
Because why? What would even be the point? There was no point in direct. I mean,
Defense may call next witness.
if I had crossed, I would have pulled up the map that showed that the second to last witness, the detective, testified about recreating his flight from the SUV to where he was captured.
One second, Your
And I would have asked, do you see Dunbar Street? Yes, right there. Do you see Arlington Street? Yes, right there. Would he have been running in the same direction toward both of them? Yes. Done. If I had crossed, that would have been the entirety of it. Just to get that map on to reinforce to the jury
The defense calls Christopher
that
Bertram.
there was no contradiction there.
Thank you.
Because once again, that witness seemed very friendly, very competent, very pointless. She didn't see anything.
I presume the state heard that and was assisting. Thank you.
I
My assistant.
I didn't want to assume.
I
So
wouldn't
Thank you for
Yes.
think they.
clarifying that.
I mean, I'm tempted to send a letter
Looks like this one's a lot closer than before.
to the
Right,
sandwich
good
man,
afternoon, Mr. Bertram, if you would please make your way to the
asking him
witness
what
stand,
kind of
which
sandwich
is
it was.
Off to my right, it is up one riser. When you get there, please remain standing, raise your right hand. And my clerk Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Have a seat, please. First thing I will ask you to do is to state your first and last names for the record.
My first name is Christopher and my last name is Bertram.
Could you spell those, please?
CHRISTOPHER BERTRAM.
Thank you. As long as you sit close to the table, you will not have to lean in. Go ahead, sir, your witness.
Not going to help him again.
Go ahead, your witness.
First of all, good afternoon.
That's
What do you
the
currently do for
song
a living?
We Deserve from Bob Dylan.
I do electrical work.
Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our mechanic friend.
Were you aware of a parade going on that evening?
I'd call it verbal dyslexia.
Around what time were you taking your mom's car to be inspected?
I don't recall.
I think she said
Do you
it's a
recall
brand
seeing
new courtroom.
Anything that caught your attention?
You'd
that
think
evening?
they'd put a
Yes.
warning
Can you state what that
strip.
was?
A smashed up red car.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
That's true.
And
That's why I
at
try
the
not
time
to
you
be
observed
petty
this
about
smashed up
his
car, as you say,
use of the English language.
did you see anyone
He just
driving it?
Yes.
he forces it out of me.
And were you able to make a description? Sorry, description of who's driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw.
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
You made reference to giving the statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone, or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
He might have been stopped sooner with an axe, though. The British do, but they have so many unique.
Did you observe?
It's
the
not
vehicle
just
stop at any point in
accents.
time?
It,
No.
It's
So it's pretty much you just saw it just kind of just rolling past.
Yes.
they do have regional
Did you notice if the vehicle had
variations
any
of
tints?
English in
Any
England.
what?
Tents, like tinted windows.
No.
I mean, what value does this witness bring? He didn't see the event. He saw the SUV after the event. The jury has already seen the SUV.
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was it
One of my best friends is
was your
from
interview with
Birkenhead,
law enforcement
or as a
the same
Scouser would say,
evening that you saw
Birkenhead,
this vehicle, or
on the
sometime
Wirral
after?
Peninsula.
The same evening.
I couldn't understand him the first couple months I knew him.
Do you recall stating during the the interview that evening that
But
you
remember, I
observed
was
the
in
driver as a
Durham.
black male with short hair and
Geordie is a
short beard?
difficult
I
accent
don't
to
recall exactly
understand
what I
too.
said.
Do you recall stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
No.
Yep.
And
Northeast.
what did you think at that moment that you
And the
saw the
thing is,
operator of
they'll
this vehicle reach down?
in the Northeast, they
I
will
was
tell you
unsure.
in Durham, it's a different accent than Geordie, which is the Newcastle accent. They'll tell you Gateshead and Sunderland across the river have a different
Do
accent.
you recall in
I
your
can't hear it, but
interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
and that's it. That's like the Appalachian accent comes
And
because
where did
it
you
was a
observe
lot
the
of
vehicle go
Scottish
after it had
settlers.
passed you?
My
I turned
sister
away after it passed me.
did her bachelor's and first master's in linguistics, and it's pretty fascinating.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
I do not remember.
Do you recall during your interview with law enforcement that evening stating that you thought the operator was
Can you
wearing a
tell the
black
difference
sweater or
between
jacket
the
as it drove past
Durham
you?
and
If that is
Geordie?
what is written.
Like I can tell
Do you
Scouse
recall
versus
seeing it?
Geordie versus
No.
uh, Lancashire versus the hardest for me is Glaswegian. That's just that's impossible.
And do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
And was anyone present with you during your interview with law
But some
enforcement
of
that
the
evening?
West Country
Yes.
accents can be
And who was that?
terrible
My
too.
mother.
And by terrible, I mean hard to understand. They're wonderful accents, just hard to understand.
And do you recall what agency your interview was conducted by?
Yes.
And would you stay for the jury and the record?
For the jury
FBI.
and the record.
Do you recall stating
My
in your
grandpa
interview that evening with law
from
enforcement
Utah
that you heard
said Warsh.
a lot of gunshots?
Yes.
And do you recall I think that's a little bit
And
unfair to
corn
say.
was carn.
If you had to estimate
Horse, farce.
where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
Durham generally is ranked number one of the British universities for their English programs. And one of my friends over there was doing his PhD on I think he was doing the legend of King Arthur, and he had an old English copy of Sir Gawain and the Green Knight. It's English. It's old English. I couldn't read it.
Do you recall seeing the vehicle that you observed crash into anything?
No.
Cajuns can be difficult. Well, it's a conspiracy if they look at the jury.
Do you recall stating in your interview with law enforcement that evening that the vehicle appeared to slow down while traveling down
That's
Prospect
probably what I
Court?
meant.
Yes.
I am not an English PhD. But remember, it at that time, it was the language was completely different. It's not just that they wrote
At some
the
time after
words
observing this vehicle, did
phonetically.
you call 911?
There was a
Yes.
lot more French influence. It
Do you recall around what
it
time you
was
called 911?
more
No.
Anglo-Saxon and French influence, not as much of the German influence that has crept in
Do you
to
recall
modern
shortly
English.
after seeing this vehicle uh, texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
Possibly.
So when I was at Durham, the author was, or the chancellor of the university was Bill Bryson. Um, and he has a book exploring the
Did you see anyone else in
evolution
the
of
vehicle?
the English
No.
language from Old English to modern English. And I haven't finished it, but it's pretty fascinating. And
But you do recall
Bill
seeing the
Bryson,
operator wearing a black sweater.
I
I don't remember.
he spent the evening at my college pub or our college bar, and so I spent a good 3 hours chatting with him with a small group of friends. He's a great guy.
Did you observe at any time
I
that
really
evening
liked Bill
seeing someone
Bryson.
run from the vehicle?
No.
And remember, lots of British spelling is the wrong spelling because Americans have the right spelling. The British changed it to differentiate. They added the U to differentiate from American spelling.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
Like
I
you.
don't remember.
Grounds.
His answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross?
Once again,
You may step down and you are
a
excused.
pointless witness. It didn't help the defense at all. So what's the point in crossing?
All right, go ahead and call your next witness.
And when we get to the next break, I have something to discuss outside of the presence of the jury. That pleases.
That would be nice.
Do you want to do that now or after your next witness?
We can.
All right, I'll address a legal issue and we'll bring the jury back in when we're ready. I'll rise for the jury, please.
I wonder what this issue is that he desperately needs to issue. It would sound archaic, but it would be understandable. 1700s.
Everyone can have a seat and then we'll just wait for the door to close.
They might not understand
Mr.
us, but good old American
I'm
fart.
curious. some of these, judging by the reports,
There's some YouTube videos
how are some of these answers allowed
about the vowel
to
shifting.
pass when they're coming straight from reports made by the people on the stand? Very curious.
They're
I don't
not
understand your
reports
question. Are you?
from the people on the stand.
I'm not sure what you're asking.
They are reports
I'm
about
asking-
the
what I'm
interviews
asking is-
from the people on the stand.
Reading from the report that the people on the stand are giving, the report that they gave to
Susie said
to
her
law
dad is
enforcement.
from American Fark.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution.
It's not a strategy.
I see right through it.
It's not a strategy. They're following the
Don't have
rules.
any
You're not.
cross-examination. Mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that
No.
is completely speculative.
They
on your
have
part,
not.
without any
Obvious.
basis in law
Especially
enforcement.
not
Obvious.
your witnesses.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't
Knigget.
done that. So for you to say that right now is
Monty
without
Python
basis.
did that pronunciation very well.
If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any
I don't
more
think I have
legal
to. I don't
advice
think I have
further
to.
than that.
I don't think I have to
So
call any other witnesses. That's
if
not
you're
on the
asking me to
stand.
strike their testimony based
I
on your
didn't say
perceived,
anything
then that's
about that.
all right. Then
Stop
I'm going to bring the jury
arguing.
back out and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
He's
The
asking
legal issue is what,
legal procedure.
how is the state allowed to
The state hasn't done anything.
coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's
These are your
obvious. I'm not
witnesses.
stupid.
Yes,
Well,
you
I
are.
disagree with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a
All of a
foundation.
sudden, the
with
state
these
don't got.
witnesses.
All of a sudden,
You
for
are
the first time in
stupid.
trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry
All
up.
of a
We
sudden,
just
they
gonna
don't got
we
no
just gonna let
cross.
these people go.
Well, this is
And
They're
argument-
your
man,
witnesses. The
This is
prosecution
argument
is
on your
under
part,
no
sir. It is
obligation
pure
to
commentary
cross
I just
on
want
them.
this
that on the
point.
record. I see through it,
And your
Nice try,
see-through
but I see through it.
has
You see
absolutely
through
no basis in
But
fact.
I know that's
Their
what's being
strategy
done.
of not
You could
crossing your
ask these
irrelevant
You could
witnesses.
Come on,
ask
man.
these
You got the right
witnesses
one.
certain questions
I'm
and you're
far,
not.
far from an idiot.
They're your witnesses, sir. If you believe
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find it
ask them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today.
I
They
find
are
it very-
done with other
your
witnesses.
I find it
witnesses.
very funny that these are their reports, and now all of a
They're
sudden,
not their
you can-
reports.
Oh, I saw the person.
They're
in the
police
car.
reports.
Oh,
Mr.
but,
Brooks,
I
this
saw
is
the
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr.
You
Brooks,
can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm
Exactly.
instructing you
It
to
brings
avoid the
nothing.
commentary when the jury comes
No,
out. You
but,
will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
Before we do that, there's a issue that we do need to take up potential as to a witness by
Yeah,
the name of Abel Lescano. He has prior criminal history.
Thank you.
it would have been devastating.
So as long as the jury's out, we should probably discuss that. I would like.
So one of his
to
witnesses has a
defendant
prior
and
criminal
report
history.
with a copy
So that had
of
to be.
the-
That had to be said. So it's the defendant.
That's not
Shut
how it was said.
That
Ah.
was how I
completely
said. You want to
disagree.
run the record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
You're
this
the-
is to benefit you.
Apparently
so that
Brooks
you
is the
understand
tone
that
None of this to
your
police.
benefit me.
witness
So let's be
has a
clear
And
about
prior
yet-
record.
He's
Your Honor, when I leave
he's
the
been the
table,
one
I'm away from
barking
the
and
courtroom, and I
yapping
have to
all
elevate my
trial,
voice.
but he
This
tone
is the-
polices.
So she
Alleged
had
The woman
record of
prosecutor.
Abel Lescano.
Stop talking.
Oh man,
Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more
Stop
interruption and you're going to be removed to the
talking.
next
That's
courtroom.
what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003, criminal trespass to dwelling
He needs
from
to stop
2006.
driving.
I need to take a break.
and
This
drinking.
man right now is having a stare down with me. It's
Look
very
at him.
disrespectful. He pounded his fist. Frankly, it
Look
makes
at
me sick.
him.
And we're taking a break.
He has steam coming from his ears. The jury is not in the room. Did you see that look? And I did hear the pound of the table, the pound of the fists on the table. The judge brought it up. But he's not going to be in there when they come back. And I'm going to take a real short break. I'll be back in just a sec. I'm back. Yes, there is a tablet. So he can just watch it on my stream. Problem solved. Um, did Mike call her a naughty librarian? I remember him calling one judge a naughty librarian. I haven't actually watched his coverage of this trial because by the time I'm done, I'm done. um, but I remember him calling a judge a naughty librarian recently. But there might have been a couple. Deb would, oh, I would love to see her facial expressions during this trial. Debbie Davis is amazing. And Lily is she's the attorney that was in the protection order hearing down in Georgia, isn't she? Can't remember her last name. The the blonde one that went on Mike's channel. She's deaf. She's all well. And that's it. Mike, his last few lives have been this. He's been streaming the entire last couple days of trial. I think it got to the point where he just couldn't avoid it. It really has put the sort of law tube community on hold. um, oh, could you imagine if this trial happened in Judge Maribel's court with Hurricane Katrina? Could you imagine? I think we'd still be on opening statements. We'd have heard 1,001 Maribel parables by now. I think I might have nightmares tonight just thinking about it. I mean, if I lived in that county, well, or practiced in that county, I would actually charge a surcharge to represent people in Maribel's court, just knowing the amount of time it would waste. And that's it. Debbie Davis is petite. I don't know how tall she is, so I can't call her tiny, but she definitely owns the room when she's in it. She's in full control. Okay. Sh Judge Davis is the naughty librarian in the Java Injustice number 3. 'Cause like I said, I think I saw him. I think I saw it. Um, I finally last night got around to the most recent Friday Night Frenzy from Law and Lumber, and Rob and Kurt from Uncivil Law started off just going back and forth, grounds, grounds, grounds. It amused me. She definitely can lure you in. Well, she's in control. Debbie Davis, and here's the here's the amusing thing. Oh yeah, it's all about little Mikey the goat. Um, I I just assume that everyone who is here also watches Law Talk with Mike and therefore knows about Davis's channel, Debbie Davis Says. Um, but the funny thing is, I actually have an aunt. My mom's sister is named Debbie Davis. So, but she is definitely not a prosecutor and definitely not in Michigan. Judge Simpson would have lost patience by now. Um, but once again, you see Judge Simpson in his dealings with James Johnson and Jeremy Shue. He he has a short leash on them, but he does reset and he starts each hearing friendly with them. Um, they the thing is, from the outside looking in, it's easy to say that Judge Darrow has been overly indulgent of him, but the reality is ensuring this is the one and only trial in the end saves time. So it's frustrating, but I think she is handling it in the right way. Um, Judge Alex Manning, the stay out of Fulton County judge, would have kicked him out of Waukesha County by now. Of course, Georgia does have the death penalty. Um, and judging by the Fulton County DAs, he would still be sitting in lockup unindicted because it hasn't been 365 days yet. So they'd be years from trial still in Fulton County, despite Judge Alex Manning and her best efforts to keep things rolling. Um, that's the one. Pre-trial. Yeah, Samir Siraj Morrow Bay, I believe, is the Morris driver you're referring to, Sean. Um, and Debbie catching out the domestic abuser sitting in the room with his victim when there was a restraining order, a stay away order, whatever it's called in St. Joe County. I mean, Debbie is a married woman 1,500 miles away from me. I love her. I've never met her. I love her. She is, and it is that platonic. She is such a charming person. She just, I think she would be a pleasure to hang out with and interact with. Oh, were were you and your wife, Si, the ones that Judge Middleton spoke to on the stream, uh, from the back of the courtroom? Because I remember that happening at least once, where he had fans from out of state who attended court just to see it in person, and Judge Middleton asked them where they're from, where they're staying, gave them suggestions. So my brother-in-law actually grew up not in St. Joe County, but in that general area, and his mother was very involved in the local politics. And since judges are elected there, here in Utah, they're appointed and then have retention elections, unopposed retention elections. Um, so I asked uh, my brother-in-law's mom, so in your political days there in southern Michigan, did you ever run across Judge Middleton? And she's like, what's his first name? Jeffrey? I think so. I think I was at a function with him. So it really is a small world. Um, it I mean that's such an infamous hearing. I the and Debbie is so smart that she picks up on the verbal and nonverbal, just the behavioral cues. And I mean, that wasn't just in the law tube community. It wasn't just played on Mike and Natalie Lawyer Chick, and it was. I mean, I think Schrodinger was even still alive and played that on his channel, so he was the big channel. But it was played on the A&E court show. What that plays court clips. So it got millions of views. And that's it. I think there's no way to fake being the person Judge Middleton is. He comes across as so authentic that it would take an Oscar caliber actor to fake that. And these I think in Michigan it would be the circuit court. Here in Utah it's the district court that hears felony cases. Those are important. But with Judge Middleton, the district court here in Utah, the municipal courts, the vast, vast, vast majority of criminal court contact happens in those low level courts, hearing the infractions and the low level misdemeanors. Here in Utah, West Valley hears infractions and all misdemeanors, but most hear infractions and C's and B's, but A's are up in the district court along with the felonies. But still, the vast, vast, vast majority is in those low level courts. So you need good judges in there. and prosecutors. So I think Judge Middleton is that kind of judge. He knows the county, he knows the people, he knows the victims, he knows everything, but he's firmly compassionate. Hey, wow, I've got my first spam chatter here, and let's block it. So Judge Hurley retired, didn't he? Um, but that settler agent person clip is one of the all-time classics. Or could you imagine the other judge down in Florida, that the adios judge, um, he wouldn't put up with this either. He'd be done. Exactly. But the thing is, he wouldn't talk your ear off. He would have you in stitches laughing at his stories. But he'd also listen, and he'd remember the stories you told 10 years later. So I believe he is a Cuban judge. He has an accent. It was the girl that was clearly still high and walked off saying adios, and he called her back, and she had Xanax bars. It's been played over and over on all the channels. So, oop, sorry. And then, there's the judge in Kentucky, one of my favorite sovereign citizen clips. You know, how do you have jurisdiction over me? And in his very Kentucky accent, I can prove to you right now that I have jurisdiction over you by asking my deputy here to handcuff you and take you back to the jail cell. And proceeds to do it to well, I think there's two clips with that judge, because there's the one where the friend in the back row starts yelling and screaming and gets arrested, and then the defendant does the same thing, and the lectern gets knocked over in the struggle. And okay, that was hilarious. That one was. And I totally believe him that he didn't know that it was his sister that had put it as his Zoom name. He
Were before.
Artie's first soft sit clip was
I'd
that
like to continue by bringing the jury
hippie
out
couple,
momentarily, Madam Clerk,
wasn't it?
and having you call your
Because
next
he had
witness.
that one. Well,
I trust that
he
you're
did
ready
a
to do that, sir.
compilation on the Artrexis Lives channel
All right, then.
before he even
We need to
started
keep
Artie's
that
corporate
stuff.
Oh,
fiction.
we do. I knew I would left something in
Because
my
he's
office,
he
but
had
I
that one
reviewed
clip
it,
that
so
went
go ahead.
viral
What is the
with
state's
like
request then
5
as it
million
relates to the prior
views
record?
We believe
on
the
his gaming
proper
channel.
Answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously
I mean,
would not
that might have been,
everything
because I think it was a
OWI second
compilation,
on down, we
but
believe
that
to be
is so many
appropriate.
years ago that
There's also one that's
I've been following Artie
069.
for a long time.
It was a case, but all the charges were dismissed. In
My
records, so
channel's
not
new,
counting
but
that file.
I remember the Talisman World videos and a couple others.
Please. Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Lozano.
On
That
loop.
was going to be kind of my next topic once. Thank you. I look at this.
He needs to watch that on loop at a high volume.
All right, Mr.
Him and Artie
Brooks, do you
were
have a
the
position
inspirations
on,
for me to start my channel.
the prior convictions for
And
this witness?
his death
The state
actually
is asking for a determination by this
delayed
court.
me starting my
that
channel as
There
well.
are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose.
No Gale.
And that would be for a determination under 90609.
Although I'm so desensitized that I didn't care about her, just Artie's reaction.
What?
Huh? What? What's going on?
I don't know what you're asking.
Mr. Brooks,
They're
you
asking
may
you
recall
about
at some
impeachment,
point, I believe we had a discussion
Due
about
to-
prior
prior criminal acts.
convictions.
The witness you are calling has prior
I
convictions.
think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't,
No, there was one state's witness that had one prior that
Yep.
we discussed. and
that's
the court
right, we
ruled.
did. I recall now. So at that point, I directed your attention to 90609.
Not that
And
the
then I made a
state
ruling based
even
upon
needs
the
to cross this witness.
factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
He has no idea what's going on. None
Like it's
whatsoever.
nine on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039. 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in. 2X MBJ, which would be 2 times misdemeanor. bail
No
jumping,
idea.
Dismissed and read in. So no convictions from that.
I've tried to avoid outside media so that I'm just
Oh, I was on the
reacting
sheet.
to the trial.
This would be an accurate listing of the cases that.
So
you found
I
in
really don't know.
investigating the witness's background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
I mean, they probably don't need.
Any statement you want to make, sir, on what the
Well,
number of convictions?
Once again,
court
this
should
would just
consider under
be a
90609?
situation on cross. And sir, do you have any criminal convictions? Yes. Done. They can't ask. So you have
What is dismissing?
4 drunk driving convictions, don't you?
Does that mean there was no charge?
No, it means it was,
Dismissed.
when
Like
there was a
count
conviction for something
77.
else. The charge was dismissed and read in, and then the court considered it at the time of sentencing.
Like, you
So
know
they are
how
not
you made a big
convictions,
deal
but
about,
it was a
well, why
case.
did the state
So
dismiss
that's why my
count
understanding why it was
77?
listed.
It was dismissed.
So the two. So where it says dismissed and read in, that would be the restraining order and the MBJ.
He has no
Right,
idea what's
misdemeanor
going
bail
on.
jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in. And then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8 should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
Whereas the OWI first was probably an infraction. Or
So there's no crime for OWI.
first.
An OWI first would not be a crime, it would be a forfeiture.
He doesn't know. He has no clue. And he furrows his brow as if, well, I don't understand this, so maybe you can help me.
I still would say 8, just based on the fact that it is.
They
continued
have, but they're
OWI.
not discussing his record right now. They're discussing his
All the way
next
to a fifth.
witness's record just for impeachment purposes. If they even choose
Remind the parties
to
of the
cross-examine him.
factors to consider for exclusion include the lapse of time since the conviction, or in this case, convictions.
Which it's been
rehabilitation or
15
pardon of the
years
person convicted, the
since.
gravity of the crime, the involvement of
But he
dishonesty,
committed the
false
same
statement in
crime
the
multiple
the frequency of the
times
convictions,
with
and any
4
other relevant factors. So
OWIs.
based on that, do you have any argument that it should be less than that?
Less than what, 8?
Will it be less than 7?
He
There's
doesn't
7
know what's going on.
convictions as I count them.
He has no clue.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7.
That's what they said.
Should be 7.
That's what they said.
Right.
They're counting
Do you want to
7.
make any argument about whether any should be excluded under the statute
They're asking you
based upon the factors?
if it should be 6 or 5 or
Well,
4
you-
or
you
none.
already made reference to one of them not being a crime.
One of the
So that
8,
brings it to 8. I don't understand.
but
the
they can't
whole-
bring up one of the 8
Well, for
because
example, the
it's a
last conviction
forfeiture,
was
not
in
a crime.
2007. It's now 2022.
That's 15
Do you want
years.
to make an argument to the
Usually
court that
10 years is
perhaps
kind of.
he's been rehabilitated?
He has no idea what they're even
I don't
discussing.
want to speculate on the next man's life, but if it's 7 on here,
He has no idea what this is even about.
well, I guess it
He
brings. it to
doesn't
7.
know why they're discussing it.
Whether OWI first is not a crime. It still counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first.
But they can't ask, did you have 4 OWIs?
It's like 7
They can
to me.
ask, have you been
All right, then.
convicted of crimes?
Anything
Yes.
further?
How many times?
State on that.
7. Done.
Given the number of convictions,
It's not buffering, Steve.
actually, although
It's
the first one's
404
not
brain not
crime, the
found.
OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Lozano before he testifies, Your Honor, I believe.
I agree.
And this is
Stay
if
willing to relay
they
that
even
information.
bother to
I'd rather
cross-examine
not,
him.
given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it
Once
be
again,
Mr. Lozano?
he's
Because if it
accused
is, I'll just have him
them
come in now and I can go
of
on the stand
win-
and advise
of
him.
witness tampering, essentially.
May I ask who's present right now?
For sure, Mr.
So,
Hayes and Mr.
and
Lozano, and
he
I'm
says
not
they've
sure the
witness
330
tampered
witnesses
with his
I think are
previous
probably
2
on their way.
witnesses, which
They're
is
on their
why they didn't
So
need to
Hayes and
cross-examine
Lozano
them.
are still here. Yes. All right.
The prosecutor's
Those are the
right.
two who are here, sir.
We'll only interact with them in open court on the record, outside of the
Either
presence
way,
of the
let's
jury.
just bring Mr. Lozano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please.
And you know he won't call him next
Can I have a
just to
first name
be
for this witness, please?
obstructive and waste more
Please.
time.
Abel, but I believe it's pronounced a different way. It's Abel.
Abel, thank you.
Abel.
Subject matter jurisdiction, Your Honor.
Shut
He
up.
declines to address that.
Still has yet
He's
to
so
clarify
annoyed.
the for the record.
Your objection
Just
is
look
noted.
at his body language. He's so annoyed.
Do you want Mr. Lozano on the stand, or are you going to call Mr. Hayes first? Just so I know what to do when he comes in.
I don't currently I can't find paperwork from Mr. Hayes. Can
Well, that's your fault.
police report or something be provided?
That is your
Call Mr.
fault.
Hayes first.
You are disorganized.
Yes, we will
and that
accommodate
is
that
your
request.
fault.
It'll just take me a minute, Your Honor, to find it. I'll have to have it printed and brought over, or Mr. Witchell can run. Thank you, Mr.
I will give you
Witchell.
permission to email it to Teresa and she can print it in the courtroom. That
Well,
will assist.
it's part of a 700-page PDF, so I can't just email one page.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
That's all right. You can do it the way that you need to.
Or you can say, Mr. Brooks,
Right,
it was provided in discovery.
Mr. Lozano, I'm
It's
just
your
gonna have
fault for
you,
not having it.
For a moment, take a seat. You're not going to testify just yet, but just come up and take a seat just at the end.
Oh, come on. You jinxed us, Steve.
Have
Now
you been
the
convicted of a crime?
feed is
The answer should be
buffering.
Yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then. Thank you.
He's so angry.
All right, then let's have the jury brought out, please.
I have a feeling he's removed again before the day's over. Oh, and Schnookums has a headache. I hope it's an aneurysm, not just a headache. Exactly. You knew who you were calling today. It's your job to bring the materials you need in order to examine him. If you don't have to call him. You can wing it. You can find your discovery. You can organize your boxes better. That would be amusing with dreadlocks. Like, I mean, I imagine if you're pulling out hair, pulling out a whole dreadlock at once would be dreadful.
Thank you, everyone.
I
Please be
apologize for
seated.
that.
The defense may call its next witness.
Defense calls, is it Jason Hayes? Jason?
I knew it. I knew he wasn't going to call
All right.
that one. He was going to call the one he doesn't have the police report for, just so he can complain. They haven't given me the police report yet. Why haven't you printed it faster? He'd be better off if he hadn't. Like I've said,
Is it Haynes or Hayes?
sometimes it is better to not call any witnesses at all for your defense. Cross-examination
Good afternoon, sir.
gets you there
Please make
better.
your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
What are the bets that Mr. Hayes is a great prosecution
Thank you.
witness?
Go ahead, sir. Your witness.
Yeah. I mean, opposing counsel has made me heated before. There have been some real jerks. There was a
Except for value.
prosecutor in a
Use document for the record.
municipal court that was a real jerk. I didn't like him at all. But my client didn't have to deal with him.
Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
Been doing that for a long time?
21 years.
Yes, a long time. The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
What were you doing that evening?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
Were you
I
scheduled
didn't
to do
pay any attention at all to that case.
marching in the parade itself? or
No.
just
Did he not
spectating?
put on defense witnesses?
Yes.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah, yeah.
I just wanted to make sure there was.
Yeah. He answered. He answered. Anything unusual catch your eye that day that you recall?
A dangerous lunatic driving a red SUV.
What did you see?
Besides the parade,
Yeah, I'm sorry.
I mean, parades aren't an everyday
That was
occurrence.
unusual that caught your eye that evening.
well, where we were, yes, a red truck came through where we were. It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that
We
time?
were all the way at the beginning of the parade.
Okay.
Like it was Main and
Notice,
corner of Main
all
and
his
White
witnesses
Okay.
are at the beginning of the parade,
You said you
They're
observed
not
this
at-
vehicle.
where the dancing grannies were, or
Honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it? I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
good witness so far, Brooks.
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
It's possible.
do you recall
I mean-
stating that it honked several times?
Every
I don't
And
recall.
when you were initially-
witness that gave a police
recall.
report is probably in those boxes. And
So
but I don't know how he decided who to call.
did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main, east. Well,
Through the
same
parade.
route the parade went.
Except it would have
Uh,
gone west.
Did you get a description of who was driving the
It
vehicle?
traveled
You saw
east
that?
I did
to
not.
west.
Did you get a license plate?
I did not.
License place?
Do you recall if the vehicle had any tinted windows?
No.
How does this matter? It's almost like he's calling people to impeach them, but
I'm assuming at some point
he's not
You were-
impeaching them from anything.
where you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did. By a detective.
And do you recall if that was the same evening or
It was not the same evening.
so?
It was a
that-
couple
days
days
prior?
after.
At this point, there's no point. Unless a good fact comes out for Brooks,
Do you recall
There's no
in that
point.
interview that you had with the detective stating that your kids were playing in the road,
especially-
the operator of the vehicle
It-
honked the horn several times?
it
and
shows
veered
to the
left and
jury,
out the kids.
you know, we're so confident,
So in your
and this
opinion,
did
it wasn't trying to
so
strike the
little.
Correct. Yes.
We don't need to cross. Because I think the jury does see,
kids. And
oh
after it
wow, the
continued,
prosecution
I think you
doesn't
said
even
east.
care about these
That
witnesses.
be correct, east.
Yep.
Did you see the vehicle strike anyone when
I
you
did not. No.
Because you didn't hit people right at the beginning of the parade. You did a couple blocks down.
Do you recall what side of the street the vehicle was traveling on at that
It was
time?
on the right side.
The right side.
So that would be the north side.
So we were on the north side of the road.
So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never
Yeah,
saw
I
it
mean, the
go to the other
jury
side
sees,
of the road?
wow,
or-
the
No.
prosecution's not wasting our time with pointless questions. The prosecution's not wasting time arguing with the judge in front of us. And bear in mind, I'm not always like watching trials like this. I'm not
No
always
further questions.
on the prosecution's
Ready,
side.
Cross?
Yes, just briefly.
Oh, I'm
Good
I'm
afternoon,
surprised.
Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
It's cross-examination, numbnuts.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that
Hold on, there's been an objection.
I guess the
Grounds.
objection to be what officer is being referred to.
Who cares?
Overrule.
He's not identifying an officer. He's saying if he saw an
I guess I was
officer.
asking was that referring to the interview officer?
No.
Objection
Dumb.
is noted. It's overruled.
Is he serious?
The question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
It's not speculative.
Do you
It's
also
what he
recall
saw.
telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify
leading.
anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
Once again,
No.
you can lead
All right, thank you, sir.
on
Those were all my questions.
cross-examination.
Thank you. Any redirect, sir?
Briefly,
He does nothing briefly.
very briefly.
Except freeze the stream. I even plugged in today, not relying on Wi-Fi, Ethernet. Come on. I'm blaming Law and Crime for this and YouTube. Apparently the stream said, you know what? I've had enough of Brooks. I've had enough of Brooks.
The defense may call its next witness, please.
Clearly it was very briefly.
Quick question before I do.
Who's
supposed to be
here?
arriving at 3:30?
Who's
Just
here?
so I know.
I'm not sure.
Babietz and Darrell will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
I knew who's here now. Just
So you
be
should
clear.
call who's here
I'm
now.
going to call Mr. Liscano.
It would appear so. He's the one that's here.
All right. Then he may.
He's salty that Mr. Liscano is the one here.
Correct?
I mean,
The defense is calling
it was a good cross-examination because
a bail.
it got in again that
We'll have him go
hey,
ahead. Thank you.
the police officer chased him on foot. So it actually was a good cross-examination. And it was short, it was to the point. It brought in bad facts for Brooks, and then it was done. It didn't necessarily need to
Please make
happen.
your way to the witness
But
stand.
It was
When
properly
you get
done.
there, please remain standing. Raise your right hand. And my clerk Teresa, who will be across from me. or in
He's
the
so
session, will
salty
right there.
that he doesn't get to choose the exact order when he's the one that refused to provide an order or to procure them
First thing I
in
will
his
have you do
order.
is to state your first and last names for the record and spell each.
Abel Lascano, ABEL LAZZANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Liscano. What do you do for a living currently?
I'm a hairdresser.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
I mean, fair point. Just eating it on your own on the direct instead of having the prosecution do it on
recall
cross.
The night of November 21st, 2021 pretty well? I know it's been a minute, but
Stop with the
Best as
commentary.
I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade, or
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
At
I
the
was
front.
standing in front of
beginning.
the Corey Insurance on Main Street.
Okay.
I'm sure that's at the beginning.
Is that part of Main Street close to like a side street, if you recall?
It's not too far from Maple.
Do you recall the side streets being barricaded during the parade?
I don't remember.
If it's close to Maple, it's actually kind of midway.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
You recall something other than the parade?
I
catch your
noticed
attention
that.
that day?
And sometimes
People getting hurt, yeah.
sometimes it actually is a good strategy. If you
And
have
what did you
something
see that
that
day,
your
if you recall?
witness will be
I saw a red
impeached on,
SUV
just bring it
follow with a
out.
bunch of people.
Bring it out. It looks better if you do it.
And
Sometimes.
did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
Oh! I like that answer. Did you
And
see
how
the
many
driver?
people did
Yeah,
you
you're
see in the
standing
vehicle?
right there.
Just one, the driver.
You.
So, do you recall
Once again, a good prosecution witness.
flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
I did not. The court reporter.
I'm gonna attempt to see if anything brings back some recollection.
That's would something be able to refresh
First,
your
do you
memory?
recall the name of the officer you flagged down that evening?
Officer Moss.
Oh, is that Chris Moss?
Do you
Who
recall
we
telling
heard from?
Officer Moss that you observed 3 or 4 people in the SUV as
Officer
you
Moss,
passed you?
who
I don't remember
was
that.
the first to respond to the SUV when it was found, who secured the scene. Is that the Officer Moss? I bet it is.
So,
One or the other.
to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
Didn't stop him from seeing you. almost like tinted windows isn't what he was focused on.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Is that all you recall about your description?
That's all I remember.
Looks a little windy out my window. That might be why the stream is a little off and on sometimes.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I mean, the reason you bring up the criminal convictions on cross-examination in the first place is to sort of impeach their credibility.
Maple Street.
You're a criminal, so are you really going to be telling the truth here? So just by bringing it up first, you're like, so you've been convicted of crimes, no big deal.
And did you see the vehicle
You're here
stop
now.
on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop. No. It kept going through the parade.
I haven't been able to figure that out. The only thing I can think of is if he's going to claim there was someone in the back of the SUV where the tinted windows were holding him at gunpoint saying, drive, drive, drive. Other than that,
do you recall
it really doesn't help him.
Law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this. I'm referring to page 4 exactly.
Is it his statement?
Statement this witness personally wrote.
I doubt it.
I don't think he wrote it himself.
So it's a summary written by another person.
So it's hearsay.
I don't know if it's Officer Moss or Detective Moss. I'm not
So
sure.
it's hearsay.
What his rank is.
Continue with your questions. I'm going to deny the request that you show the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss?
He might have.
That you observed one where it says one was described as running southbound on Maple towards College Avenue. Do you recall that?
No, I don't.
I think it's just the back cargo area windows that were tinted.
The other 2 were described
or at
as
least
running in a
darkly
westerly
tinted.
direction from the rear of 338 Maple Street.
No.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
Come on.
Barely, a little bit of that.
I mean, and the thing is, if he saw people running from the vehicle, did he say they got out of the vehicle and ran, or he saw them running away, as in they're running from a madman in a vehicle?
Wearing those items that evening.
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle.
Absolutely.
Where I spotted it.
He's leading and he objects when the prosecution leads on cross, even though it's allowed. He's been told it's allowed.
Just so we have clarity, describe the subjects you saw.
And that's it. Why stop?
I don't remember that good.
the opposition from
You
making your
shot
case
him,
for
so
you.
It brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
He flapped his
I was
arms
walking
and
my
flew
family back to
there.
the car. Trying to get him to safety. So I was keeping an eye out and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Once again, this is he's acting as if he's cross-examining him.
Do you recall why that
But
would
this
be
is his
reported?
witness.
No. When I found it, it was parked already.
It's his witness. He's not cross-examining, trying to throw off his credibility. It's his witness. Why even call him if you're only calling him to impact his credibility? If Brooks had taken
Do you recall
the other turn in
when you
Albuquerque,
initially had
we wouldn't be
the
here.
interaction with Detective Moss?
Of course, I think
Do you
the wrong
recall
turn is the one that brought him to Albuquerque in the first place.
leading him to where the vehicle was ultimately found?
Yeah.
Do you recall yelling at subjects standing outside of a building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Still leading. At some point, just to get it over with, I would start the leading objections. Exactly.
Do you recall why?
I mean, the only potentially
recall
good
why
fact
the
he's
report
brought
says
out
that
is, did you see 3 people running? But they,
You
once again,
advised Detective
were they
Moss
running out of the vehicle or
that there are 3
from
black
the
subjects,
vehicle?
specifically black subjects running from the vehicle?
No, I don't remember.
Because once again, people were running from the vehicle because it was a dangerous weapon. So if they saw it coming toward them, they would run from it. And in a commotion, not everyone processes what's going on.
Were you yourself injured in this incident that evening?
No.
Did you file a claim? Do you know the plaintiff? He hasn't done his sovereign citizen questioning yet today. At least not a victim or witnesses. And here, I don't know that especially since he already asked about the convictions, I don't know if I'd cross or not. I'd potentially say, so did you see those 3 people get out of the vehicle? No.
Do you recall stating that? Well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
Yes, I did.
And do you recall if that was Detective Coates?
I don't remember his name.
Still leading.
So it'd be fair to say that you spoke with two different law enforcement officers that evening.
Yeah.
He can count to 2. Wow.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall
Once again, we
in
have
your
video, we
interview
have
with
photos
Detective Coates that
of
evening
the
stating
escape
that
as it drove
you
down
could
Main
not
Street.
provide any
We have
description of the occupants
photos
other
of
than
him
that they
in the
appeared to
driver's
be
seat.
African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed
He observed
African
you.
Americans in this vehicle that you saw.
Yes,
correct?
you.
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much.
So they were
they
probably
stood out.
the residents who came out to investigate.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
His individual
Any reason why
questions
the Detective Coates would
are
report
so long.
that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
So once again, he didn't see anyone get out of the vehicle.
Do you recall
At this
in
point,
your
that's what I'd do on cross. Did you see
interview with
anyone get
Detective
out
Coates that evening
of the vehicle? No? Thank you very much.
stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so clarification. The 3 individuals who were standing in a line, shoulder to shoulder, as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
Seriously, stop.
And look, like they were standing in front of
If
it.
he answers you, that's his answer. You don't have to ask it again. And again, this isn't cross-examination. Stop leading.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
I don't remember.
What are the bets these I don't remembers cause Brooks to melt down once the witness is off the stand? Because it's clearly the prosecution coached him to not remember.
Any reason why multiple, well, I'm not gonna say multiple, two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
And during the parade incident, were you or anyone you were with injured that evening?
No.
He said no already.
No further questions at this time.
At this time,
Thank you, Andy Cross.
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
I haven't counted, Si.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in
It
the
doesn't
parade.
count unless it's on
Do
the
you remember
record,
what
for the
group
record, and let the
of,
record
people
show.
in the
So
parade?
you've got to
Do you
ask
remember
it 3
anything about
times.
the name or the banner or the costumes or anything like that?
Objection leading.
Overruled, Ms. Cross.
No, I don't.
Speculative. Objection.
Overruled. The witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overruled.
It was crowds. I mean, when it was coming through.
I mean,
when
he
I
was near
standing
Maple
over my
Street.
daughter and my wife,
There was a
I
lot of
saw it
carnage
coming
near
through.
Maple Street.
And at first it looked like it was just pushing people out of the way, and then it just kept swerving back and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay.
And while the witness was giving the answer, not the last answer, but the one prior to that, he had his right hand in the air, directioning.
Make a full record.
His hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Thank you. So, Mr. Lascano, I want to talk about the moment when
I noticed
you located this
prosecution
vehicle
did
on Maple,
not
okay?
object
I'm gonna
once,
ask,
on
Madam Clerk,
direct.
could you please turn on the AV system? We're going to put up.
even
State's
though
Exhibit
they could
65.
have to most questions. Brooks is
Go ahead.
desperate and objecting to almost everything. Just going down his list. Objection leading. It's cross. They can
Objection
lead.
to the
Objection relevancy. Objection
Exhibit
speculation.
65.
Noted, overruled. It's been received. The state may proceed.
All right, this total clip is 36 seconds, but before.
You
we
mean
can
only he
play
can
it, sir,
ask
do you
questions?
recognize the area on the screen that's shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection.
Okay.
Speculative.
It's almost like
Overruled.
he doesn't
Answer received,
understand
said, I
the
believe.
meaning of the word
And would you agree with me,
speculative.
the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
It's
Overruled.
cross. It's
May
cross. You have been
That looks
told
right. Correct,
multiple
sir?
times.
Objection leading.
It's cross.
Overruled.
She can
All
lead.
right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor?
Overruled on you didn't bring a proper objection.
Is that a tacit agreement?
No, she doesn't have to respond. And remember, you see him run out at the top, sort of a little way to the left. Just now, you see a white blur, and that's Brooks running from the car.
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, I did not.
Okay. Now you
We
said
heard from the
you
dog
did
walker in
see,
that clip.
by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection, mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection, stated it was black males. Asked and answered.
She has not.
Witness may answer.
She has not cross-examined
Go
this
ahead.
witness.
2 or 3 standing by the vehicle,
Okay.
and then on the porch there was maybe 3 or 4 or more people. I don't know if they were.
He's
I'm sure they were
desperate.
white, but
Okay.
I was trying to not make it obvious because at the time, I believed that they were with the vehicle, so I didn't want them to see that I saw them. So I just did what I
Understood.
thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
If he knows
No, I
people or
Would it
not,
be reasonable, do
not
you think, Mr.
speculative.
Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection, there was never any crash mentioned.
I'll sustain. Calls for speculation.
did Mr. Lascano,
Mr.
did you
Lescano,
see
is it
anyone?
possible that the people you
get
saw
out of the
standing
car?
near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection, mischaracterization of testimony.
No.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection, speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like
He's
that
getting
in State's
mad.
Exhibit 65, did you?
No, I did not.
Oh, look, he's so mad.
You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection, speculative.
It's not
Overruled.
speculative.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection, speculative.
Grounds.
Overruled.
You
That
said that.
mischaracterizes the testimony.
No, it does not.
That was not testified to before on direct.
Oh, your objections are
That-
overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it,
you?
no.
Okay, just wondered. Mr. Lescano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case through your testimony?
Objection, hearsay.
It's not hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection, hearsay.
Overruled.
It's not
No.
hearsay. But once
Thank you,
again,
sir, I don't have any other questions.
Thank you. Anything
Brooks.
direct?
Yep.
accused
Go ahead.
the prosecutors of tampering with his witnesses.
You stated
But
that
They've never spoken
you
to
saw
him.
the driver, correct? Of
Yeah.
the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
Like you.
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had any
But once again,
anything
we've had
noticeable about
very
the appearance,
good
tattoos,
witnesses
scars,
as
marks,
to
anything like that?
his identity.
I saw the side, the profile, the side. You were flying fast down that street. I wasn't paying attention to the color clothes you were wearing.
that
And it was
the
a
other
black male.
courtroom we're seeing for
and I was
some
supposed to be
reason?
it. It's the first thing I told my wife.
Good job,
'cause he was a
Court
black guy
TV.
driving.
Come on.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
It's not an alleged driver. There was a driver.
And in a couple seconds time, you were able to make out the driver's profile and race
Yeah.
just by a couple seconds.
Yeah.
Yeah. It's not hard. They tell if you were white or if you were black and if you had a beard. No, that's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
It's almost like he was looking at your face.
So that leads back to the question of, is that the only person you saw in the vehicle?
Asked and
I remember,
answered.
yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's
fair,
the only reason.
would it be fair to say that
No, it's not fair to say.
when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives,
Seriously,
that you
dude.
observed
End
3 or
this.
4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both
Asked and answered.
detectives.
Asked and
2 different
answered.
detectives the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not
Come
where
on.
the vehicle was
Asked and
later
answered.
found.
This is just.
Any reason why you stated to both
This is
detectives
getting ridiculous.
in relation to what
By
you saw
by this
at
trial's
the parade,
standards, by Darrell Brooks's standards, this is
by
getting
both
ridiculous.
detectives in their reports stated that you
Stop
told them
testifying,
that you
Brooks.
observed 3 or 4 people in the SUV at the time of the parade.
So what's your question?
That's
Question
it.
is, why did you
He's
report that
pontificating.
to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the
He
vehicle.
has not watched Perry Mason even.
That's the only reason I said that.
So why would you report that you saw this during the parade?
He has explained it on and on, over and over.
And during both interviews with detectives that evening, the evening of November 21st, 2021. You also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Honestly, that was painful.
We have additional witnesses here.
Yes, Your Honor, they're ready.
All right.
He doesn't know who they are.
There's 2 left.
Okay. So the 2 left on your list. Your next witness, sir.
Is mommy there?
So I'm guessing that's, oh, I know who it is.
You should know. They're your witnesses.
One quick second, Your Honor. One quick second.
Go ahead.
That's an awfully big coat there. I guess October in Minnesota, you might need that big winter jacket with the fur-lined hood. I'm not ready for it yet, though. Of course, it was chilly this morning, but my computer says 74 outside now, so. But it still could snow this weekend, so who knows? Is he actually organizing his evidence, or is he just exerting control again?
Sorry about that, Your Honor. I'm just making sure I have the correct paperwork.
You should have the correct paperwork. Because they're, once again, I know this is a difficult concept, your witnesses. It's not the prosecution's job to hand you the evidence for your witness
Reporters
right
not staying.
before.
Go ahead.
It's your job to hold on to the discovery the prosecution provided you and to have it ready to go. I realize that's a difficult concept. And once again, this could be him exerting control. It could be him being childish. Well, I don't have it. Give it to me again. Maybe he should check his Bible for it. That seems to be where he keeps lots of his garbage.
Paperwork.
The Howard Hamlin deputy is so over this trial. His mouth has been a straight line across the entire trial, but you can see his eyes. He's over it. I am definitely ready for the weekend. I mean, the prosecution doesn't yet. They're going to be working this weekend. I mean, even with the witnesses presumably being finished, if he rests, they're still working this weekend, even if it's just putting the finishing touches on their closing argument, triple checking the jury instructions, getting ready they're doing prep work on their next case
Okay, I'm ready, guys.
too.
Go ahead, call your next witness.
Kathleen
Urel?
Urel.
That's how I think it is. We'll find out. All right, ma'am, if you
He's
please
barely
make your way
literate.
to the witness stand. When you get there,
I
please
don't
remain
think you could
standing.
pronounce
Raise your
Smith
right hand, and
without
my clerk, Melissa,
guidance.
who's on my left will swear you in. Go ahead and come all the way up. Thank you.
Yep,
Do you solemnly swear that
Clearly,
the testimony you're about to give shall be the
he
truth,
has
the
never
whole truth,
spoken
and
with
nothing but
them.
the truth, so help you God?
And
I do.
what's
Thank you.
the
Please
number
have a seat.
one rule of questioning a witness? Don't ask a
First
question
thing I
if
will
you
ask
don't
you
know
to
the
do is to
answer.
state your first and last names for the record and then spell each.
Kathleen, Kathleen. Last name Urell, Yourell.
Thank you so much. Your witness, go ahead.
Good afternoon, Miss Urel. Is it Urel?
Urell.
Urel. What do you do for a living?
I'm in workforce management for a call center.
Oh. No.
November 21st, 2021. Directing your attention there.
That already makes her a bad witness. Call center.
You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while.
Or she's tried to block out
You
certain
recall
things.
what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial meaning maybe
I'm just
10
joking
minutes?
about
Until my group
not
of
liking
children
call
went by.
centers.
Okay. Do you recall where you were positioned during watching your group participate in the parade?
Yes, on north and east, right on the corner.
I'm assuming call center means telemarketers.
If you're
It could
going
be like customer
parade
service
route, it would
inbound
be on the
call
right-hand
centers.
Just so we have clarification, can we pull up the exhibit? I believe it's 15. Thank you.
Go ahead. And thank you.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet. Just I want to make sure the witness gets a chance to view it first. Can you see that on your screen yet?
I do.
And using the touch screen, it's a touch screen. Can you point out where
It's
you?
not published. So do
Oh.
you want it published?
I'm sorry. Yeah, publish.
Sorry, I didn't mean to interrupt, but I just wanted to point that
So
out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the
Okay.
jury.
Fair.
Okay, go ahead.
I have a feeling you're right.
I think we got to wait on the jury, right?
Thank you.
For the jury, and can you
She
using
definitely
the touch screen
isn't
on your
looking
screen,
at
can
him
you,
with fondness.
point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching
right on the corner. Sorry. Oh, well,
it.
if you want to
Can you clear?
reverse it
Can you
again,
clear
I'll do
the
it again.
arrow?
We'll clear it. You can do it again.
Yeah.
So right at the beginning.
If you don't want, do you want the arrow?
Well, it was to the.
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was
Can
gonna
you
say
clear
that.
Well, I mean, it was right there, but.
I was gonna say a circle or a little dot if.
Well, I thought I would do the dot. But...
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
There you go.
And you said that would be approximately East Main and
Hopefully,
Northeast.
her husband has a
Correct.
nice mega pint of wine waiting
And do you
for
recall
her
if those
when she gets home.
well, there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
Once again, he didn't enter
We can
from
take,
those streets. He
exhibit
didn't try
fifteen
to
now.
exit
Thank you.
onto those streets. And even if they are barricaded, he could have stopped.
And you said you
This is
stayed
a
at the parade
stupid line of
until
questioning.
your group had passed.
Correct.
And
And what group was
what
that?
time did you leave?
I can't determine the time. It was right after my group of kids went by.
Which group? Who were they marching with?
And where'd you go from here?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And
They are
so at some
bored out of
point
their
your
minds
attention
by
got
now, I'm sure.
drawn to
They're
something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? That'd be fair to say first? I don't want to assume.
Yeah.
It's almost like you should ask
at that point.
non-leading questions.
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were?
I would
on
hope
your way
so.
to get your vehicle.
I think I need more specifics from you to give the details you may be looking for.
Yeah, he is asking pretty vague questions.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening? At that
Are you
point?
asking a compound question?
Nothing of that nature.
Are you leading?
Well, all I can say is that I was walking past White Rock.
Oh, so she
Did you see
witnessed
anything that may have alerted your attention
you
at that time?
assaulting Erica.
Yes, a car coming through the parade at the beginning
Oh, well.
on White Rock where the parade was starting.
Oh, so she
So
saw
when I
you
left,
enter the parade.
I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were.
I mean, I don't think
walked
anyone
across
was
the
run
street.
over at this
And
point. But
at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see where did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across. When I was thinking it was going to leave the parade route, if you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade. And it went right to if you're looking at the parade, it was on the right-hand side. And it's continued on into the parade.
hey,
Hold on, just for
this
the
is a
record,
good
she was using
prosecution
her hands during
witness.
her testimony. I just need,
Left.
that's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record.
I think she's
Go ahead.
already
Next
done
question.
I want to back
with
up a little
Brooks's
bit.
nonsense,
When
too.
you first observed this car, as you say, you recall that it was blowing its horn.
Yep, the horn was beeping.
Which, once again, excuses
Do you
murder.
recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
But were the windows
Do you
tinted?
recall if you might have seen multiple people in the vehicle at that time? Or?
Unfortunately, due to the time passing, I cannot recall.
Did you see a license plate?
Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
Once again, why did he call her? Other than to get in that the horn was honked. When the very first witness, the officer
at the time that you observed
testified the horn
vehicle,
honked.
did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
Hang on. I thought the judge took an oath as a public servant. He's the only one.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was.
Driving a lot faster than the parade.
All I can state is it wasn't speeding.
What do you mean by speeding, though? Because was it driving over the posted speed limit, or was it driving faster than the parade that it drove through? There is a distinction.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Exactly. And that's it. If I'm prosecution, basically the only thing I get up at this point is you say the vehicle wasn't speeding. Was it driving faster than the
Close enough that
parade?
it could have easily have clipped me or the two people that were in front of me.
Were the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
That's probably it.
Good afternoon, Mr. Rell. Thank you for being here.
And they
You
probably
testified on direct examination that you don't
highlighed
recall
portions
whether or not you
of
saw
her
more than
statement
one
and then
person
decided
in
not
that
to
vehicle
call
we're
her.
talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember
That's
going.
it. Sometimes the freeway
as to,
25
the
is
topic of
speeding.
conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading witness.
Yeah, I
Overruled, you may answer.
I can't be too sure.
Overruled, you may answer.
Can you say that again? I'm
He's
sorry.
I
desperate.
can't be too sure. Again, some of the conversations I might have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
All right, thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street. Is that right?
Correct.
Objection.
Come on, don't do this.
Already answered that, asked and answered.
You asked. The prosecution
Correct.
And
can
after
ask in order to
children
clarify.
walked by in the parade, you walked in this direction towards the intersection of White Rock and Main. Is that correct?
Objection,
Correct.
leading and speculative.
Overruled as to both, you may answer. If there is another.
He's just trying to exert power.
Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street. Is that correct?
Objection leading.
Yes.
Is that when you saw this vehicle we've been talking about?
Objection leading.
Yes.
So you were standing in the crosswalk.
Correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was.
He is, except when
Was it clear
I
to you that
mockingly
traffic from White Rock should
object,
not have driven
then he-
onto Main Street
Yes.
then he doesn't to make me
unless they
look
were part of
bad.
the parade?
Yes.
Did it appear
It's all
to
a
you as the
conspiracy
vehicle we've
against
been talking
me,
about
not a conspiracy
parade?
against Brooks.
No.
I'm the
How
real
many children
victim
do you have,
here.
Ms. Darrell?
Objection irrelevant.
Overruled.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled.
Sorry.
Your oldest daughter, Charlotte, she was 14 at the time?
We heard about
Yes.
Charlotte before, didn't we?
She was marching with the Extreme Dance Group as an alumni, wasn't she?
We heard
She's
about
handing out
her.
candy.
Objection.
There was an
Come on.
objection. It's overruled.
I didn't even state why I was objecting, but
And it's overruled.
we still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
That's quite a distance
You
away.
didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry.
Overruled.
Okay, I'm sorry.
Objection hearsay.
Overruled.
I mean,
I did not.
Did you see them later that night?
once again,
Objection leading.
her kids were hit. And he called her as a witness for
I
himself.
was only able to see 2 of my children that night.
When did you see the other 2?
He seriously called her.
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care, and the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled.
Shut
Yes,
up.
Father, and
He can lead. This
Charlotte
is
suffered a
cross.
chipped vertebrae from being struck, didn't she?
she did.
Objection
Sorry.
leading.
Overruled.
Instruct him, Judge, that
She did.
leading is fine.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia.
Yes.
So that's both bones in
and
the
broken
lower leg
metatarsal bones.
Yes.
and foot,
She was observed in a concussion protocol, is that correct?
ankle.
She was.
Your daughter Vivian, she was marching with the Extreme Dance Group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
He can lead, you monster.
Yes.
And road rash
Extreme road rash.
and a lung contusion
Ow, ow, ow.
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Objection
correct.
leading.
Overruled.
He was walking with the Extreme Dance Group handing out candy. Is that right?
He was.
She's great for the prosecution, though.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
Oh.
An open.
Open compound
I mean, the
fracture.
bone came through the skin.
Yes.
Objection hearsay. I don't believe he's a doctor.
Overruled, the witness may answer based upon personal knowledge.
Was that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound. Is that correct?
Remember,
Yes.
the femoral artery is frequently severed with a broken femur, and you can bleed out. This explains why she had a murderous look from jump.
Let me call your next witness, please.
I mean, in what world do you call her?
Thank you. We'll take it down.
In what world do you call her as your witness? But you know, it's okay that he severely injured 4 of her children. He beeped his horn 4 blocks away. It's their fault for not hearing the horn 4 blocks away and getting out of the way.
Please call your next witness.
Just 1 second.
I don't blame them. I mean, I could be if I weren't feeling such rage. I mean, we've seen Brooks, you know, have his meltdowns and, you know, performative tears. Where are they now, Brooks? Where are your tears now?
So you want more person here, right?
It's possible.
It's my understanding, sir.
He's a monster.
Would that be correct, Attorney Upper?
Yes, she's in the courtroom, ready to go, Your Honor.
And that's it. If you have a veteran 27-year prosecutor in tears, they're not performative, they're real, and I guarantee it takes a lot to put her in tears from testimony. But for him, he'll have real tears when he's sentenced.
Defense calls Catrice. I don't know how to say the last name.
Can you give me the spelling that you have?
Babiasz.
Like it's Babias. What's your last name? Babias. All right. Thank you. You are at the witness stand. Would you please raise your right
She has a
hand?
pretty
That's where
accent,
Teresa
I
will
think.
swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record.
That is a correct statement.
Catrice Babias, Katrice Babiasz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
How can he traumatize her today?
Miss Babias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
That's a good way to pronounce his name.
The evening of November 21st, 2021. Were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade
He
shortly
probably
after it started.
ran
so it
over
was
her
right after
grandmother.
4. p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where
Probably
were
at
you
the
positioned
beginning.
I was towards the beginning of the parade. I was on
Hey,
Main
wow.
Street,
Imagine that,
where
the
it
beginning.
connects with White Rock Avenue.
Because once again, every witness he's called has been to establish that he honked his
Did
horn.
anything catch your eye that evening when you were positioned watching the parade with your family?
Yes,
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
I really think that's the only reason he called her.
And
because honking
do you
excuses.
recall, to the best of your knowledge, it's been a little bit. The driver of the vehicle you observed was honking his horn. Was it gesturing to people?
Yes,
yes.
you were gesturing.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver
being a
gesturing?
clown.
I'm sorry.
Gesturing.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
For the record, the witness had her right hand up above, probably at a,
I'd make it everywhere I go a lot faster if all I had to do was
I
honk.
would say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on
as a dispatcher,
what you were observing,
as
the
a
driver of the
dispatcher,
vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained us to the form of the question. Please rephrase.
How did you yourself take that gesturing?
that you're a clown.
I took that gesturing as the driver was telling people to get out of his way.
He has no clue. And the thing is, he got the files from the public defender.
Back up.
There's no indication that the public defender actually intended to call any of these witnesses.
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
Ooh.
And how did the driver look?
Like you.
The driver looked like through me.
What do you mean through you?
Okay.
Describe what you mean by through.
That the driver looked
very
through
hard
me.
to explain that look.
He did not
but it was
care.
Very frightening.
That. Oh my. Oh. Oh.
Do you recall what the driver was wearing?
They would
The
have
driver
tried
had
to destroy
a,
her on cross, but
hoodie,
never would have called
sweatshirt
her
or
back.
sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100%.
But that
Were you
he
able to see
looked
me here?
right through
I did
me.
see here, yes.
How would you describe
As
it?
in, he did not care
The
that he
hair on the
almost
head
ran me
was
over.
in front, like dreads down here from what I could see underneath the hood of
Hey,
the hat.
that's a good
And then there was
identification.
facial hair, beard and mustache.
That's a good description of the
Hold
driver.
on, I just need to make a record of she was also using her hands. That's okay.
She's such a good prosecution
indicate,
witness.
At the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen.
That's
from,
it. You don't have to ask
the
what they do for a living
Thank you. Go ahead, sir.
unless it
When you
somehow
observed the
adds
vehicle
to their credibility, or
was the
you
vehicle
know,
speeding?
if they're law enforcement or.
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
Or the reason the prosecution asked it so much is they had to establish lots of their witnesses either as law enforcement or as experts or as the
To the
custodians
best of
of
your knowledge,
record.
do you recall there being any barriers present where you were positioned at?
Yes.
It would have been nice if she had. Several witnesses have in the previous couple days, and he gets all indignant. What do you mean by you? That's true. But once again, it has
Do you
nothing to
recall
do
if the
with her
vehicle you observed had any
testimony
tinted windows?
in and of itself.
I do
Like
not
she
recall.
wasn't on duty.
Were you able to make out a license plate number of the vehicle,
License
being
plate.
that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children.
Hey, as a good mother would be. Even a mediocre mother would be. Emotions definitely play a part.
I'm assuming at some point you spoke with the
You're
law enforcement
assuming.
about what you saw
You're
that evening. Would that
assuming.
be fair to say?
Yes,
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
He doesn't know where to go from here. Like I said, I think the mass murderer, formerly known as
At what
Darrell
point
Brooks.
were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
It's almost like they had a lot of people to interview. More than the Waukesha police could handle.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said.
That's
to
that's
them.
what our guess was like on day two.
But I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
It's almost like it's a year ago and she doesn't remember exactly because she hasn't looked at pictures of you recently.
Just a little bit ago, you said that, well, when asked the question of did you recall here, for
They tell
the
him
driver,
you're getting neutral oaf tonight, and he says grounds
you stated and made the gesture
for the
that the hair
neutral
was
oaf.
in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
So is he going to arrest after this, or is he going to try to delay and get mommy into the courtroom on Monday morning?
Do you recall? Well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle?
Yes.
Were you injured the evening of the
She
the
wasn't
incident?
hit. She was
Yes.
almost hit.
You were
Oh,
injured?
Yes, I was.
oh,
Any reason why that's not reported?
that he is not.
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense.
Brutal.
You talked to
That's
FBI
brutal.
agents a few days where you said you didn't. To be fair, you said you didn't know. You said it was that week. Is what you said. The same week.
Stop
Spoke with
arguing.
FBI agents.
Stop arguing with her. Stop
Reported no
testifying.
injuries.
They didn't ask me about injuries.
Well, would it be fair to say
Stop
that kind of information would
arguing.
come up when talking to law enforcement, seeing as how you yourself
Stop arguing with
work in law
her.
enforcement? It just seems odd, don't you think?
Stop
I do
arguing.
not. I was not physically injured.
Oh.
He didn't specify when he asked. He asked, "Were you injured?"
But you didn't report this at any time whatsoever. Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement? Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Exactly. But
Did you
he wants to be in control.
file any claims related to the incident?
No, I did not.
Since she works in law enforcement, is he going to start with his plaintiff questions?
So is today your first time bringing up your alleged injury?
No, it is not.
Thanks for hanging out, Susie. Such a bad witness for him to call.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall
They would
when
like
you spoke
to.
with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
He's desperately trying to impeach her credibility,
You contacted
even though it's his own witness.
Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
That's how you do it.
You ever spoke with anyone directly at the
The
district attorney's office?
witness coordinator, yes.
No, correction. Yes, when I walked in today, I met there and let them know I was here. And then they walked me into a room and I waited until I was called.
So before today, you had no interactions with anyone related to the district attorney's office besides I think you said victim advocate?
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Once again, this is his witness.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
I believe just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals.
To identify
she wanted to make the
themselves
witness aware.
as who you were
I just
talking
wanted to
about.
point it out for the record since it happened.
He thinks
Working
this
in
is a
law
Perry
enforcement
Mason
for
moment
16 years,
again.
I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement, no.
She works as a
You've
dispatcher.
never
She's generally not a witness on
witnessed
the
a
scene.
trial, sat at a trial, been in a trial?
Compound.
I have not.
Have you ever testified in any way before today? Grounds.
Overruled, you may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in a courtroom, correct?
How is that relevant?
I know where they're sitting, yes.
I mean, she didn't specify she testified in a criminal trial in the first place. So she wouldn't necessarily, from that experience, know.
Want to back up a little bit
But-
to the observation of the vehicle the evening of November 21st, 2021.
He's still just trying to exert control.
While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
It almost struck her.
from your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When it
the,
was approaching.
when it was.
Let her answer.
I'm
Hold on,
confused.
hold on, everyone.
Let
The
her
question was
answer.
asked. This witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question
okay.
that as you understood it.
Yep. So I saw that an officer have to get out of the way. And he was attempting to stop Mr. Brooks from
Oh, that's right. Use his
driving
name.
through the parade, and he was at the last minute jumped out of the way from
Except Mama's
the vehicle,
testimony
otherwise
won't
he
do
would have
anything
been
to
shot.
save him.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
She already
I don't understand your
identified
question.
You just used the name
that she knows.
Mr. Brooks for the first time since you've been testifying. Is that fair to say?
She saw you
That's
there.
fair to
She
say.
sees you here.
Why
She
haven't you
knows the
used that
name of the
name
person.
You've been up there for quite some time.
I didn't need to.
Exactly.
So what changed for the last question that you needed to?
This is argumentative.
I don't understand
Stop
the question.
him. This is
You
just
stated
argumentative.
that you didn't mention the name before because you didn't need to.
This is
So
argumentative.
what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
It's because your questions before that didn't call for her naming you. She knows what your name is. It would be on the subpoena form. It's on the case. State of Wisconsin versus Darrell Brooks. Just like she understands where the prosecution's sitting, she knows where the defendant's sitting. She is nowhere near as dumb as you are. They're even better than his confused faces.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
When you subpoenaed her.
You just stated a little bit earlier in testimony that you received your subpoena in July.
And then
I
you
said last week.
subpoenaed her last week.
Those are both correct.
So you
The
received
state-
two separate subpoenas?
Correct.
Yes. The state subpoenaed
What
her
was the
in
difference
July.
between the two?
You subpoenaed
One
her
was
last
from
week.
the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Probably did. But so did the
What's
one
a
from
case
you.
caption?
Just 1 second. 1 second, Your Honor.
Objections.
I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
There is now. There is now.
The objection under 906.11, I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
No. No.
Then you need to ask your question directly, sir. Go ahead. Let's
Your
stay in
name
the form of the
has
question.
nothing to do with what she observed at the parade. Nothing. Absolutely nothing.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to
This
the
has
case you were being subpoenaed
nothing
for?
to do
Objection to relevance.
Grounds.
with what she saw at the
Sustained,
parade.
you don't have to answer that. I sustained the objection on that, those grounds. Ask the question, I believe that you're trying to ask, not that one.
And I mean, I know what he's trying to ask,
It's
but
the name that you
it's
mentioned,
irrelevant.
Mr. Brooks.
It's so far from
Anywhere on
being
the
of
subpoena
any
that you received from
consequence.
the district attorney's office in July.
Objection, relevance.
Grounds.
Sustained,
It
Grounds for
has
sustained. That
not
was-
relevant.
It has nothing to do with what she saw at the parade. She's testifying about the parade. And she's your witness, and you're trying to impeach her credibility based on the name on
So
your
what-
subpoena.
In July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained, not relevant.
She's testifying in the trial. It's not relevant that she got subpoenaed.
Mr. Brooks,
I
she's here under
have
your subpoena.
Ozzy Osbourne has a song called Perry Mason.
You called her
So
as a
that's the
witness.
song in my
The
head
subpoena
right
that
now.
the subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
90611, please ask the witness a
This is
relevant
mind-boggling.
and probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
Shut up. Stop with the mumbling. Stop being rude. Ask a question or
So were you
let her
aware
go.
that it was a chance you would be possibly testifying in this trial?
That's what a subpoena does.
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained,
Grounds for
relevant.
sustained.
it's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr. Brooks,
I think
I'm
that's very
sustaining the
relevant.
objection under 90611, and I'm asking you to move on.
I think so.
It's ridiculous,
But he also thinks she knows my name now, but she didn't at the parade, so that's a conspiracy.
Seems to me like a like a lot of your answers are coached. Is that fair to say?
She's your witness.
No.
She's never met them. She testified she's never met them.
So the subpoena that you got last week,
Yes, he's a sovereign citizen.
is that how you learned the name that you used?
Go back last week. He had an epic
Grounds.
sovereign citizen rant.
Grounds.
Asked and answered.
Every
She's
break
indicated
he comes back
the answer already.
arguing
90611,
subject
sir.
matter
Next question.
jurisdiction.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor
It's
answered.
not
90611,
relevant.
Please ask a question, sir.
She told you it's not relevant.
Oh, man, this is ridiculous.
Shut
Mr.
up.
Brooks, if you don't ask another question that's relevant and probative under 90611,
Do it,
then I
Judge.
will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right?
If they even cross-examine her, what's the point at this point? Why would they cross-examine her?
Your Honor.
Ask a question, or I will declare the examination by you to be ended.
It's not an examination. It's direct.
It's a direct examination.
Direct examination.
90611, you are directed to ask a question, or I will
I
ask
heard,
the
I heard
state
you.
if they
I
have
heard
any
you, Your Honor.
questions.
I heard you.
Then ask
I
a
heard you.
question.
Next question, please.
He has such contempt in his body language. Well, in his actions in general.
Know who the plaintiff is in this matter?
Hey, shut him down. Shut him
Yes.
down, Judge.
Who's the plaintiff?
The state of Wisconsin.
Shut him
Is
down.
that an entity or a living human being?
Shut him down.
Grounds.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Come on. 90611.
Sustained.
Vague.
End it,
As
Judge.
to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
End
do not
it.
answer that question.
90611.
Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You're both.
It's 90611.
Under
Judicial
90611, I
control.
directed the witness not to answer that irrelevant question. Ask your next question, sir.
End it. He's so mad. The prosecutors have nothing to do with this. Stop staring them down.
Mr. Brooks, ask your next question.
I'm gonna get to it.
Then
Thank
get
you.
to it. Stop staring the judge down, too.
So when did you first report your alleged injury?
Asked and
You
answered.
do not have to answer that question. Next question, sir.
Grounds for
90611, sub 1, sub A, sub B, and sub C.
He hasn't read 90611 yet.
All right.
He hasn't
May
listened,
sit down. Does the state have any
when
questions
you-
for this witness?
read it to him. He's so mad. I doubt he sat down yet. I was right. He's so mad.
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
That's it.
What were their ages on that date?
They see his body language.
objection?
3
relevancy?
and
Overrule, the witness may answer.
Of course, it's gonna be overruled.
Shut up, Brooke.
3 and 6.
And I don't know, Mr. Brooks sits it down. And I'm asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
He's
not
about
saying
to be
I would ask you
removed.
to sit down, please.
He's about
That
to
is
be
disrespectful
removed.
to this witness and to the state and to the court.
No, it's not.
Yes, it is.
Not doing anything wrong. I'm merely standing here.
Which is wrong. You are supposed to be seated.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered it.
Not by the
Mr. Brooks,
prosecution.
it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question. I asked.
Yes,
They can ask
you
their questions.
you asked
Go
the
ahead.
same answer as the state
Witness may
every
answer.
time.
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
They are.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I ask that the screen be cleared.
Defiant 2-year-olds are
And
better
yes, this
behaved.
Show,
Wait till it's in the jury box.
sorry.
I'm sorry. The jury would let me know when it's there. Thank you. It's there now. Go ahead.
ma'am, do you see a purple line on that would indicate
She
the
still has
parade
a
route
cold.
going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you, I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good.
For the most part, he stopped.
Okay, thank you. Would be fair to say is to
Basically
your
when he
left
started giving his
would have been
opening.
Pleasant Street.
But it's been on
That
and
is
off
correct.
this
Were there
afternoon.
barricades blocking Pleasant Street?
There were
Objection, asked
ba-
and answered.
Not by the prosecution. How many
There were
times does she
barricades
have to explain this
that
to you?
were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overruled, the
Hearsay.
witness may answer. It's not hearsay.
So when the red
Yeah,
SUV came down White Rock Avenue and was making its turn
With the
onto
commentary.
East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
But he's also
Hearsay,
worn it
speaking
sometimes
hold
this
on.
afternoon.
Eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's because you're making bad objections.
Go ahead.
It's not a
answer.
conspiracy against you.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were
That's what we've
partially in the
said.
roadway.
I said
when
multiple
the
times.
red
It's a
SUV
good
came
thing he's
through?
masked so they
Yes, we
can't
were.
see his
Objection.
full
Mischaracterization
contemptuous face.
of what was testified.
Because his
Overruled,
eyes
the witness may answer.
have
Go
been
ahead.
so expressive, even with the mask on. But
Answer.
Can you repeat it?
Sure.
like when he
Were
was
you and your
staring the
kids,
judge
all in the
down
roadway
without his
when the
mask
red
on, you
SUV went through?
see the
Yes, we
absolute
were.
hate
Okay.
on his
You weren't
whole
part of the parade,
face.
correct?
We were not.
Okay. So were you standing
Everything's
with other people that
performative.
were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection,
daughter.
speaking as a first-hand eyewitness.
You
Because she
mean
is a first-hand
leading?
eyewitness.
No, I'm talking about you.
She can lead.
the Objection is
She
noted.
lead.
It's overruled. The question is proper, and the witness may
On
answer.
cross-examination,
Yes,
you
my
can
daughter
lead.
was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time,
He has thumbed
you
through
said that this
them.
was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade
And had your daughter gone to get candy at other times?
the entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled. The witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come
Yeah.
to your daughter?
He's been awful today.
It was
He's getting desperate,
I
and
wouldn't
the
be able
more
to
desperate
give
he
an
gets, the
accurate
worse
judgment,
his
but it felt
behavior is
very, very close.
Had you
getting.
not pulled your daughter away, would that car have hit your daughter?
And thanks for joining today.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one would have been where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that the red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
And
Remember, we
as
heard
the car passed
from that
your
officer.
location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled. The witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you
Dri-
describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you.
Ooh.
Let me read the rest.
He's gonna be awful. He's gonna forget. Redirect has to be narrow in
You said you observed
scope.
multiple officers trying to stop the vehicle. Is that correct?
Yes.
You described one that I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that the interview that was conducted with the FBI. That was who did your interview, correct?
Yes.
Exactly. And
why was there no
her not reporting to the FBI both cops that tried to stop it, even though we heard testimony from both cops
I
who
don't
tried to
know
stop him?
why it wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. That be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall, how can you recall path of travel of the
Because there's details she does recall.
Can you rephrase the question? I'm not understanding.
I mean,
I think
there's
it's clear. But I'll
stop arguing.
You just acknowledged that there may be some details that you don't quite recall.
But there are details she does recall. Those aren't
So
mutually
you say that
exclusive.
You don't quite recall the path of travel of the vehicle.
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
No.
So you recall all the details of what you
She didn't say that. Stop arguing.
No.
Besides, she didn't give her statement on November 21st, 2021.
So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I want.
Sustained is to the form of the question.
Seems very funny. Seems almost as
Exactly.
if
Now he's going to,
you recall
when the jury
don't
leaves,
recall
have another
purposely
fit
not.
at the prosecution
Objection,
laugh.
badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness.
Good.
Next question.
Shut him down.
badger or argue. What do you mean?
Next question.
What do you mean?
She means shut
To
up.
intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding
That's
her
Does she
answers
feel intimidated?
is badgering the
Stop
witness.
Are you kidding me?
Stop it. Shut him down. 90611. He's
90611,
done.
please ask
You
your
really can't
next
be serious.
question.
You can't be serious right now.
90611. He's done.
Intimidating the witness. What have I done to intimidate the witness?
Shut him down, Judge.
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling under 90611. Please ask a question or I will
Shut
stop
him
the
down.
questioning.
Shut him down.
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question, or the questioning of this witness will end.
How are you even a judge?
It definitely doesn't
You may
help.
step down, ma'am.
And how are you a judge? She was elected.
Come on, man.
She's a
This
judge
must be all
because
about
she
the
was
systems
elected.
you trust, right? That you want to be the beneficiary of.
I'm going to.
Beneficiary of
Instruction.
not
We are
trust law
setting
has
the
nothing to
testimony
do
for
with this.
Today, please do not begin your deliberations and discussion of the case until all the evidence is presented.
Shut
And I
up.
have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited
I
to
would like to
face-to-face
face palm
conversations.
with
It
my
also
knuckles
extends to all
to his
forms
face.
of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about
And his
this
face
case
has
or your
remained
experience as a juror.
the exact same the
Come in
whole
contact
trial.
with the parties, lawyers, interpreters, or witnesses.
I mean, his mouth
Do
has
not
been a
speak with them.
straight
For their part, the
line.
parties,
No
lawyers,
frown, no
interpreters, and
smile,
witnesses will not
no
contact or
expression.
Speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be
And just
helpful to
look
you
at
in
him.
understanding the issue
He's
presented.
staring
Do
her
not
down.
investigate
His
the
lip
owner
is
business
quivering
by
with
encryption
rage.
Or by any electronic means. Do not
Did
read
you
any
guys see
newspaper
his
reports
lip
or listen to
quiver
any
with
news reports on
rage?
radio, television, over the internet.
That's right.
or
Zoom
any other
in.
electronic
Zoom in
application
so we
tool
can
about
see.
this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other
He's
reference
so
dictionaries for
mad.
additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury.
I mean,
Do not
he
use
might have a
computer,
vein
cell phone, or other
explode in
electronic
his
device, including
forehead
personal wearable
or in his
electronics,
neck.
applications, or
He's
tools with communication capabilities
that's just
to share any
pure
information about this
rage.
case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer.
Oh,
Do
he
not permit
he
anyone
blinked.
to
He
communicate
lost.
with you about this
He
matter,
blinked,
either
so
in person,
it doesn't
electronically,
count.
or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the juror.
What are the
based on
bets?
The evidence presented in the courtroom.
How
People not
big a
serving
blow up
on
does
this
he
trial
have
not heard the evidence,
once the jury
and it
walks
is
out?
improper for them to influence your deliberations.
Because I think
and
we're not done
decision
yet
in
tonight.
this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to
He's
ensure that
definitely
jurors
seeing
remain
red.
impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise
I
to the
still
jury.
think he's got one more blow up in him. And the judge is, if he's
Don't call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None.
was the jury fully out when he did that?
None.
Yeah, keep slamming stuff. Slam
Thank you,
that
everyone.
Bible.
Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and
Luckily,
obviously.
he's basically
she
in
can appear
solitary.
here voluntarily, if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods.
They're not going to
Mr.
help.
Brooks talks to her
Period.
on a daily basis. If he wants her here, he can produce her on Monday.
They're done with him.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree
They're
with the state that
they're done helping him.
she could certainly appear.
It ain't even gotta be no arrangement. All I gotta say is come. She don't come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all that-
9
We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired
Then
of being
stop
in the courtroom
wasting
that has
time.
no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record.
Stop
of-
wasting
I need to
time
make a
if you
record
don't
too.
want to be there anymore.
You don't
When
need
am
to-
I gonna get the chance to do that?
All right, I need to make
You
a
mean
record
like the
that's being
hour
moved
she
to the
gave
other
you to
courtroom.
rant?
He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
It's simple.
He hasn't sat
You
down
want
for
out
the
there.
better part of 2
Guilty
hours.
now.
You can hold me in contempt.
Change
all you
your
want.
change your
holding
plea
you
to
in
guilty,
contempt.
and you can
Criminal
get out
or civil.
right
So I
now.
can hit you with you-
I need to
what
clear
you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
The
he is
crime is
claim.
murder.
And what
He
is
is. I will make the
The
record. Bring it
crime
back. I will
is
step
murder.
Off, but Mr. Brooks, you're being
It ain't
taken
no
to
Mr.
the
it
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
I mean, I knew there was another blow up in him as soon as the way steam was coming from his ears, and I'm guessing as soon as he's out in the other courtroom, I'm guessing they go back on the record. So I think we're not quite done yet. But once again, he says he's just about done. He doesn't want to keep coming back to the courtroom. He can change his plea to guilty tonight and be done. He can be done tonight. Just change your plea. No need to drag the jury back on Monday. Change your plea tonight. You just have to come back one more time for sentencing. That's it. That's it. I mean, at this point, they might have to take him in shackles. Like he's got the electronic shackle, basically the zap cuff for his ankle. At this point, I don't know. He's getting to the point where he could be violent. The way he's exploding at the judge, he could be violent. And yeah, he could waive sentencing. I mean, generally what happens, especially with a crime of this magnitude, like if we get a verdict on Monday or Tuesday or whenever, we're just getting a verdict. Sentencing will be like in a month and a half. Because what generally happens is they prepare a pre-sentence report, conduct a pre-sentence investigation, and lay out the mitigating factors and aggravating factors and all that. He can waive that. He can say, I'd like to be sentenced today, Your Honor. And my guess is a public defender does his appeal. They only do one appeal for him, assuming they even do. The As far as I know, the record's so airtight. I don't see him getting a new trial. I mean, oh, that'll be bad.
I know I'm muted.
I don't know if it'll be streamed or not, victim impact statements. That could be absolutely brutal. And I mean, at that point, he'll have been convicted to receive victim impact statements. So he will be shackled for those. And either he will be gagged so that he has to look his victims in the eye, or he'll be in the other courtroom. So deliberation is going to take longer than you think. Not because it takes a long time for them to make a decision, but there's going to be about 80 pages of paperwork the jury has to work their way through. So to get through 76 charges, not 77, but to get through 76 charges plus the lesser included, if they even have to consider the lesser included, like if they go for first degree, they won't consider second degree most likely. But going through all the
That Mr.
counts,
Brooks is in the
all the elements
adjacent
will take a
courtroom.
while.
I have verified the audio and video are working appropriately.
I'm guessing a full
I
day.
need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks.
And this echo is on the
started
court.
to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me.
And so the jury probably still heard.
He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called.
Yeah.
Therefore, it's
His
proper,
witness.
allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions.
And she told him multiple times.
They did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called.
Put that on the record multiple times.
Given his staring, given his pursing of his lips,
The steam
given the
coming
way
from
that
his
he kept
ears.
asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections. That is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the
She's just
common,
amazing
everyday
all
uses,
around, I think.
it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, or relevant question. During that time of both the frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers.
Yes.
And would roll his eyes at her.
Yes.
Or just to himself, I guess. And
yeah,
purse
read
his
that
lips
Bible.
and make other gestures.
Read that Bible. It'll
that
absolve you of all your crimes.
He did. It was apparent to this court. He did not like her testimony. And again, I'd remind everyone that it was his witness.
Exactly.
And he had the police reports
exactly
for this witness, and obviously was fully aware of her statements to the investigators.
Which begs the question, why did he call her?
I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the
and
court
in order to
remove
protect
him
the victims
at the end
and
of the hearing,
witnesses
outside the presence of
and
the
not
jury,
cost the
so that I
state
could get
millions
through
more
a couple of
dollars,
things.
they want this to be the one and only trial.
The witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods.
It won't
as
do
a
any
witness.
good. Won't do any good.
The only other witness at this point that I can identify that's been
Luckily, they won't have to deal with
the
him
court and the
directly.
state has been put on notice.
They're just going to have the
Mr. Brooks
record.
himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can.
And even
certainly
if there
contemplate
is
over the
oral
weekend,
argument for the
so that
appeal,
when I do
he
the
won't be there.
colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or
Oh,
not
yeah.
to testify.
Is he going to
The advisements
testify?
that
I
will
forgot
give
about
Mr.
that.
Brooks at the moment are as follows.
With today's fireworks, I
Mr.
forgot.
Brooks has a
He
constitutional
could
right
testify
to
on Monday.
If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination.
That's true, but he
That
hasn't been
may
cross-examined.
include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning.
But yeah, with
I will
today's
also advise
fireworks, I
him
forgot
that he
about
has a
himself
constitutional
as
right not to
a
testify.
potential
And that a
witness.
decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way. And there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury
They
instruction
definitely don't. They're sick
300.
of him.
I would further advise him that it is his decision.
He's not
and his
listening to
decision
any of
alone
this,
on
by the
whether
way.
to testify.
I'm sure he
I will
still
ask him whether
has his
anyone has
nose
made
in the
any
Bible
threats to influence his
performatively.
decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify.
I think
I,
once she finishes her
will
work,
rely
she's
upon
done for the
my-
day. She's
upon the record, specifically the record made
Unless
during
she
the
has
waiver of
something to
attorney
research,
regarding
she's
his
done.
education.
The prosecution
I will ask him
does
whether
more
he's
work.
had
She's
any
done.
medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write.
Go home and drink a mega
English.
pint to
Again, I
recover
may
from
also
the
refer
mega
back to the
asshole.
colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent or
behavior
that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed.
But is that a
And
tacit
it may ask
agreement?
that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th
He's not listening
Amendment,
anyway.
which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is
And
not
he has
absolute.
the right to
There is no
confront
constitutional right to
witnesses
present irrelevant
against
evidence. State
him.
versus Robinson, 146 Wisconsin 2nd,
which,
315.
once again, is witnesses against him, not
Moreover,
his
criminal
accuser.
defendant's right to present relevant testimony is subject to reasonable
His
restrictions.
reading of the 6th Amendment is
Citing
wrong.
to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Allen, State versus Anthony is also
That's
important,
basically
as
it,
I've
yeah.
noted previously.
But his interpretation was he was demanding
Relied heavily,
that
of course, during the
he
course
had
of
the
this
right to
trial on
confront the state of
90611.
Wisconsin
And the primary
because
purpose
the
of a
state of
criminal trial is to
Wisconsin is his
develop relevant
accuser,
facts on which a determination of guilt or
and the
innocence
6th
can be
Amendment
made.
gives him the right to
Efficiency
confront
is
his
a secondary
accuser.
objective of trial.
But it specifically doesn't. It specifically says
of
the
course,
witness is against you.
It is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again.
Asked and
If the
answered.
defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after
Pretty
he
much.
testifies. But if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks. And I expect people to be on time. And
Even me?
To be ready
If
go.
I'm on
to be
time, I
fully
can't
prepared.
go on warp speed.
And then, of course, the state, if it so chooses,
If I so
does have
choose.
the option to call rebuttal witnesses and offer rebuttal testimony.
And they don't. That's where you get a surprise witness rebuttal.
So you know for timing.
Thank you. I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home.
I think
because I do
rebuttal
anticipate
is not
a very
needed.
lengthy jury instruction conference.
Oh yeah.
And it's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes with the hope of, and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury
Still
on
performative.
Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have.
I hope it does not get a second
Clerk
season.
has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages.
Yeah, roll your eyes.
Yes, with my
Roll
advanced
your
eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font.
Nice.
So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with sorry, I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first. So the state should be prepared perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part.
It'll be longer than the opening.
How long it takes for me to go
Definitely
through
longer
the
than Brooks'
instructions,
opening.
and whether I just instruct and then bring the jury back the
Does
next
he
day.
cry through his
for the
closing, or
arguments.
is he fiery?
But that's generally the framework that
Water
I
or
intend
fire?
to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now?
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's
And I'm sure all this was already in his discovery.
Memorialized in supplement number 55 under an incident report number of W210877.
Exactly. It goes through. It takes a long time,
was a
even with full agreement,
the statement
to go through it.
by Jason Hayes.
I
to the
I
City
bet
of
it
Waukesha
takes at
Police
least a
Department,
day.
memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson.
The girl.
So
X.
for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Miss Patterson's 15-year-old daughter,
Who could have
well
sent the
as
photos herself.
their new grandchild, the daughter's child, who was born around May 1st of 2022.
So
I think
Erica
that there was
Patterson's
ample
a
grounds for the court to
31-year-old
defend Ms. Patterson's
grandmother.
testimony when it did, but
31 or
for,
32. That's
just in case that becomes an issue going forward.
That's strange
and
to
offer
me.
Proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them.
I live very close to the University of
provided them
Utah.
to a person
Our rival is BYU. We call it
Michelle,
Brigham Young
who
University.
was a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks.
Hey, wow, they've got the full chain of custody of the
If she
photos.
were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions.
Oof.
She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed
And remember,
by the bailiff
the jail,
staff that the defendant was
the
twice
jail
offered to go to his cell to
searches his
retrieve
mail.
that letter that he talked about.
So they'd have a record
Open.
of him receiving letters from her.
Thank you.
Not-
I appreciate
it's not
the
just
record
phone
being
calls.
Made. I will now unmute Mr.
The
Brooks
jail
and ask
would
him
know
if,
what's in his
there's
mail.
anything he needs to make a record of at this point.
He's an
on the
abuser.
topics that
Period.
have been raised.
He hasn't listened to a word of that. Shackles are on. Jury's gone. Shackles are on.
So, anything you wish to address before we break for the day?
Yeah, I wasn't really hearing everything that was.
That's
just
because
said.
you weren't paying attention. You were reading your Bible performatively.
Why haven't I been given the chance to offer all my filings and the evidence when I already stated that before?
All your what into evidence?
I would like all my filings. I would like every single filing that I filed.
Those aren't
placed into
evidence. They aren't
Every
evidence.
last one of them.
They are not evidence. They're not.
That has yet to be done.
They're not evidence. Besides which,
I'll
you'd
put
have
you
to
on
testify
notice.
to
I'll
get
state
them
it
into
for the
evidence
record.
somehow.
Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do.
You should have fired your lawyers then.
So this is something that's been stated on the record numerous times. I did hear
I
a
mean-
reference to
I want to eat my donut that I've had sitting right here since 10 o'clock this morning.
whatever he was just talking about is in regards to
And it's
me
4:45
going to get the letter,
now.
whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters.
And the jail would have record of you receiving
And for
those
somebody
letters.
that don't even know to try to tell me what I got.
The jail would have record.
Like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it.
It's a nice
Seems to
dark
me that- it seems to me
glazed
that all y'all
donut
want to do
that, as I said, I have the world's best dad,
gang up,
and he brought it to me
be biased,
right as I was
prejudice,
coming out for lunch.
and gang up.
It's all performative.
4 against 1. Then you sit up there early.
I'm no
and
cop,
before-
but I love
before
donuts.
lunch, you
It
sit
smells
up there and make a record
tasty.
about all this stuff that happened in Nevada. That's other acts evidence, ain't it?
And it wasn't brought in.
How was you allowed to put that on record and not even be truthful about everything?
It
that you
wasn't
said?
brought in.
But not one time did somebody say, "No, we're gonna strike that."
It wasn't brought in
Not one
before
time.
the jury,
If it had
you
been me, it
you
would've got struck.
potato.
If it had been me, it'd have been a problem. If it had been me, I'd have been held in contempt.
You could have brought it in. It's your side that excluded that evidence.
Why was the bond not addressed?
Bond isn't an issue.
Why was the statement of particulars not addressed?
That's not a thing. That's sovereign citizen mumbo jumbo.
No filings that I seem to file need to be addressed.
Jamie, you wanted sovereign
After
citizen
you
nonsense?
sat there and
Here's his
told me that
rant.
that's what I needed to do.
He's on it.
Then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you.
And do you
Which
see a
clearly
lawyer there?
states on there, I do not waive my right to assistance of counsel. And you accepted that.
But you didn't accept
But
counsel.
you still turn around and continue to violate my Sixth Amendment right. Violate my First Amendment right by telling me what I can and can't say,
In a courtroom.
which I have the right to say whatever I want to say and to be heard.
That's the First Amendment. You sit up here and talking about a fourth option that you came with out of the
And that's
blue.
it. He has
Illinois
the
versus
information,
Allen, when there is no
which
fourth
once
option.
again, you're charged generally either by indictment, which is by a grand jury,
Then
or
you try
by
to
a
stick some
document
other
called
case
an
laws in that you
information,
just came up with today. I don't
and
know if
then
you
it'll be
came
read
up
to
with that when
you
was on
at
one of
your
breaks that you
arraignment.
take. But
So
that-
he has had his
it's awful funny
bill
that
of
it never got mentioned
particulars.
before. You've repeatedly made false
Well,
records.
even then, he can't say
You wanna-
everything
you
he
wanna sit up
wants.
here and perpetuate
It still
all
has
this
to comport to the rules of
disruptive
evidence.
behavior and this, that, and the third. When you knew from the point of the start of this trial,
Well, that's
one,
the
that I
problem
wasn't clear,
then.
two, that I did not understand the proceedings.
He wants it dumbed down
Yet
because he
still
doesn't
choose to
understand
find a way
the
to get around it.
information.
Just like you found a way to get around answering what your name was, which you're a public servant. The
She's
name
not
that you
your
have on
servant.
file
Her name is not
with the
Jeeves.
Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that.
He's getting close to it.
Have yet to prove subject matter jurisdiction
He's getting close to
for
it.
the record. Have
And
yet to show
yes,
that you even
I
have a
do
license to
think
practice law.
it's weird calling a document
Haven't proven
an
that yet.
information.
And neither has the prosecution.
But
Where's the licenses? Why can't I place your
you know,
oath of
even
office
even at the federal level, some crimes
into the
are
record?
charged
Why can't I make that part of evidence?
by indictment. But sometimes people waive
The oath that
indictment
you
and they're
haven't even
charged
honored,
by
not one bit.
information, even at the federal level.
Doing enough to keep your face clean doesn't constitute being fair. Doesn't constitute being impartial.
She has held your hand
When the jury was
and
selected,
protected you
I
at
struck the whole
every
jury. That
juncture.
never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury.
That's
So
not
how
an
can you go over that
option.
constitutional right, which I
That's
have
not
the
an
right
option, numbskull.
to not pass a jury.
Mr. Brooks, I'm muting you. The reason I'm muting him is because he has not addressed a single issue that was raised at the end of this
Basically.
hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant.
It's Festivus. It's his
Continues to
airing of
impugn the integrity of this
grievances.
court and this process.
Just put
Again,
a
he did not
Festivus
address
pull
any
in,
of the issues
have
that I
the
raised
feats
at
of
the end
strength,
of
and
this
be done
hearing.
with it.
From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone
Boom.
who claims to be a sovereign citizen,
To quote
claims
Juan
that have
Galt,
no base,
boom.
that are baseless in law and in fact.
As the
I'm not going
prosecutor
to
said,
address them any further.
mumbo jumbo,
Again,
quoting
they
the
are
appeals
simply
court.
baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
Oh. What a day. That I mean, that's actually what I expected yesterday with his opening statement. But I mean, frankly, I'm shocked that we got through all of the defense witnesses, save maybe him and his mom on Monday. I really am shocked, and they do need this. I mean, when you consider how close he'll be sitting next to the judge if he testifies, they need a deputy nearby. So story time. As I've mentioned, my internship between my first and second year of law school was with the Utah U.S. Attorney's Office in the white collar criminal division. And the brand new federal district court for Utah, it looks like the Borg cube, it's hideous, opened the week before. And there was a member of the Tongan Crips gang who was testifying. He was in custody, he was in prison. He was testifying against a fellow Tongan Crip who was also in custody. He was sitting at the defense table. The one testifying was at the witness stand. The the defendant stood up. He was in handcuffs. It wasn't in front of a jury. It was just an evidentiary hearing. He stood up, grabbed a pen, and lunged at the witness and was shot and killed. First day of the new federal courthouse. Very first day. Well, it might have been, a day or two. But it like brand new federal courthouse. Bailiffs had to mag dump a defendant. And, he's a Tongan big muscular guy. He was at the witness stand before the officer could draw his gun. So as you'd imagine, this was a huge deal in the U.S. Attorney's Office. Like, they had office-wide meetings that I attended where they basically discussed, so these are the procedures we need to do to keep this new courthouse safe. And they have security video. They do have security cameras. They don't televise, but they have security cameras, and this was a big news event. So the defendant who was killed, his family had the audacity to sue the federal government over this. That's probably why the video was released. I don't know if it was released to the news immediately or if it was as part of the lawsuit. It it was ridiculous. It was dismissed almost immediately. But long story short, if he testifies from the witness stand, they definitely need to have security close by. So, with that, thank you for hanging out this afternoon. I will see you guys bright and early Monday morning for what I'm sure is going to be another train wreck. I expect him to testify. It's going to be deliciously awful. Have a great weekend. See if I can find my cursor to end the stream.